23 kgs, it was written in the list.
The
Commercial
package was not weighed.
Yes, Lordship.
Okay.
Not separately.
So because all the cases are similar,
Yes, Lordship.
let us fix it tomorrow.
tomorrow.
Wait for one day.
So I think let her come, then
No, you are not there now when the matter is called.
Okay.
So it will be convenient if I hear the all matters
All matters.
together.
Because all three, both, these 3 persons will coming.
Otherwise, because all of you will be claiming same thing, same footing.
Same.
no idea about the other matter, Lordship. Our matter, my senior has explained. Lordship, after little time, sometime.
7 tomorrow, along with the please.
Okay. Item number 57. Let this matter be listed on 2024 along with bail application number 1048/24. And item number 55 after something.
2 more criminal matters are there, 46 and 48. If taken, I will be criminal.
Yes.
46 and
46 I am there.
orders, only orders.
Yes, sir.
What is there in 46?
Yes, sir. In this matter, my Lordship was pleased to grant this petitioner applicant bail on 8/4/2024, madam. He was in custody for about 1 year, 8 months.
8/4.
24.
Okay.
Yes, page 7, my lord, it starts from page 7. And while granting bail, Lordship directed to furnish 2 sureties, madam. One should be a government servant residing within the state of Assam.
Now what happened?
My lord, I have failed to, my lord, procure
Find out government servant.
Yes, my lord. But my lord, having said that, my lord, I am ready to furnish 2 local sureties, my lord, who are specifically residing within the jurisdiction of the special court, Karimganj, my lord. I am also from.
Which is the judgment which says that after a month it has to.
My lord,
There is a judgment of Supreme Court.
Supreme Court, my lord. It's, my lord, suo motu writ petition criminal number 4 of 2021, reported in 2020.
Give it to me.
My lord, I had wrongly bought another first copy, my lord. I get the copy, my lord, and furnished into the court master.
So moto.
Suo motu writ petition within bracket criminal number 4 of 2021, my lord. Lordship,
What it says?
my lord, I'll just go through, my lord, the relevant guidelines 5, 6, and 7, my lord. And it says, my lord, in cases where the under trial or convicted.
Give it to me.
Yes, my lord. It is, my lord.
It has been quoted in some other.
Yes, my lord. Another. I wrongly.
Yes, Mr. Parashar, anything? He was granted bail on
April.
April. Now it is July.
They must have tried, my lord.
Okay, heard Mr. M.A. Chaudhary, learned counsel for the petitioner, learned counsel for the applicant. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This interlocutory application has been filed by the applicant Abdul Jalil, praying for modification of the order dated 8/4/2024 passed by this court in bail application number 634/2024, whereby bail was granted to the applicant with certain conditions. One of the conditions mentioned for release of the accused, for release of the applicant on bail was that he shall furnish 2 sureties and one of whom should be a government employee and should be a resident of the state of Assam.
46.
Stop. Learned counsel for the applicant has submitted that the petitioner is unable to arrange. Where do you reside?
Karimganj Manor, within the jurisdiction
Though
of
the petitioner is
Narcotics.
a, though the petitioner is a local permanent resident of Karimganj district. However, he is unable to arrange a government servant to stand as his surety. Stop. It is submitted by learned counsel for the applicant that though the applicant was granted bail by granted bail on 8/4/2024. However, even after lapse of more than 3 months since the date of said order, he has not been able to arrange for a government surety. Learned counsel for the applicant has also submitted that the Supreme Court of India in the case of suo motu writ petition within bracket criminal number 4/2021 reported in 2023 SCC online SC 483 has issued certain directions to be complied with in connection with execution of bail orders and number 5, 6, and 7, which are relevant to the present case, are reproduced herein below for the sake of convenience. Quote করিব ইয়াতে flag করে দিয়েছে green flag. Quote from 5, 6, and 7. It appears that in the aforesaid case, the apex court has directed that if from the date of grant of bail order to an accused, he fails to furnish bail bond for a period of 1 month, the concerned court has to take suo motu case and to consider whether the conditions of bail bond are condition of bail are required to be relaxed and modified. It appears from record that the present applicant was directed to be released on bail by order dated 8/4/2024 on furnishing a bond of rupees 50,000 with 2 suitable sureties of like amount, one of whom should be a government servant and resident of state of Assam with certain other conditions. However, next paragraph. However, from the facts and circumstance which have been stated in the interlocutory application and submitted by learned counsel for the applicant, it appears that the condition of arranging a government servant as one of the bailer for the petitioner has become cumbersome for him, and he is unable to arrange such a bailer even after lapse of 3 months of the passing of the bail order. Learned counsel for the applicant has, however, submitted that the applicant would be able to arrange 2 local sureties and therefore prays for relaxing the requirement regarding necessity of government servant to be a bailer. I have heard learned, I have also heard learned additional public prosecutor. You have any objections?
No.
Who raises no
Means
objection?
April, they are.
No objection to the same. Under the above circumstances, this court is of considered opinion that without relaxing any other condition imposed on the petitioner by the order dated 8/4/2024, if the condition regarding requirement of government servant to be a bailer is relaxed, it would serve the cause of justice. Stop. Hence, the said condition is accordingly modified. For the sake of clarity, it is hereby made clear that the petitioner is allowed to go on bail of rupees 50,000 with two sureties of like amount, within bracket, one of whom two sureties of like amount, who should be the resident of Assam. Stop. The other conditions of the bail imposed by the order dated 8/4/2024 in bail application number 634/2024 shall remain as it is. With above observation, this interlocutory application is disposed.
Deeply oppressed.
Oh. No, nothing, no one is there.
We'll call it later.
No,
48. You are for 48?
Time being.
Okay, we'll take it later.
My pleasure. This RSA is from the judgment and appellate judgment and decree dated 15/2/24, first in title appeal number 1 by the learned civil judge Borpeta. Lordship, what happens? The factual matrix of the case is that
Yes.
so far the suit land is concerned, Lordship, in fact, there is a prayer for cancellation of sale deed in respect of the present appellants who were sold the land measuring 1.5 acres approximately. Lordship, so far their land is concerned at Schedule C, that is 1 katha 1.5 lesser. So they said that they were dispossessed from the land. If that is their land, Lordship, then first question comes that my sale deeds for 1 bigha and 1.5 bighas cannot be cancelled that way because I have purchased. If I am somehow, so there is some sort of perverse appreciation of evidence by both the courts below, because the first appellate court, in fact, allowed the defendant's present appellant's appeal. Now, Lordship.
No, what happened in the title suit?
Title
The suit was decreed.
Title suit was decreed.
Decreed. The sale deed was cancelled.
Yes, Lordship.
You are the
We were purchaser from Daliman Mesa.
you were defendant.
We were defendants. The
Defendant.
seller and we. Seller is now
Your defendant number?
2 and 3, Lordship.
You purchased the land from
Defendant number 1.
defendant number 1. And that, what was the interest of the plaintiff?
Plaintiff's interest is that there were 4 brothers. Namely, Lordship, one is Mohan and the other is Kalu and the other is Arfan and the 4th one is Madhu. Madhu died before the death of Mohan. When Mohan died,
who filed the suit?
in fact, Lordship, the plaintiff said in their affirmance in the plaintiff.
Who is the plaintiff?
Plaintiff, Lordship, plaintiffs are present respondents, Lordship. I am,
All respondents.
yes, Lordship. I am taking your Lordship to page 8, where the plaintiff is filed. They are all legal heirs of the original purchasers of the land. These four brothers were the purchasers. Lordship, not four brothers, I am sorry. Two of the four brothers, Mohan and Kalu. They purchased 6 bighas of land at different slots. First they purchased 4 bighas, then they purchased 6 bighas. Mohan died, so the property devolved upon Lordship. The present seller of the present appellants and the original plaintiff, Lordship. All the heirs came into the picture, Lordship. In fact, Lordship, the present appellant as well as the respondents, they had equal shares. Without partition, there were 2 ducts, Lordship. It was originally annual patta length and then subsequently converted to during 57-64 settlement, Lordship, KP patta. The seller's father, Lordship, inherited 3 bighas of land from 1.5 bighas, I am sorry, 1.5 bighas of land from Mohan.
From Mohan. Who is Mohan?
Mohan is in fact uncle of
No,
the
Mohan is nowhere mentioned as one of the parties.
Yes, Lordship. Your Lordship will find it at page 10, Lordship. In the plain.
No, relate to the parties, then I will understand.
So far Mohan is concerned, he died, Lordship. Thereafter, the property devolved upon the present appellant's seller of the present appellant, I mean to say.
Who is the seller?
Seller Daliman Nasa, Lordship, that is the
Defendant number
one.
one.
Defendant number 1. She sold to the present
You are
appellant.
saying that defendant number 1 inherited the property from
Inherited property from her father Arfan. So she had a share. Admittedly, Lordship, entire pleading will say in the plain that
who sold the land to you?
Daliman Nasa,
Daliman
Lordship,
Nessa.
legal heir.
On what ground the sale deed was cancelled?
That is the thing, Lordship, not cancelled. There is a pleading for cancellation and that was allowed, Lordship, by the decree. Cancellation of sale deed.
Decree was for cancellation of sale
For
deed.
cancellation of
So it was, what was the decree?
decree was that, Lordship, your Lordship will find decree
Sale deed was cancelled or not?
cancelled.
Cancelled. On what ground?
Grounded, he had no land at all. Her father
The
had no
seller had no land at all.
no land at all.
Okay.
Whereas admittedly in the pleading, Lordship, he had Arfan, that is the seller's father had 1 bigha, 10 lessas of land. They say 12 lessas, 1 bigha, 10 lessas of land.
Whether the defendant was able to prove this fact that the seller had 1 bighas 10 lessas of.
It is in fact an admitted position, Lordship. Facts admitted otherwise need not be proved. This is the admitted fact, Lordship, in the plain. I will take your Lordship to page 8 again.
Page
Page 11, Lordship.
yes.
There are 6. out of an amicable family settlement, Arfan, the possessor of the defendant, predecessor of the defendant number one, who was the seller lordship, was allowed to sell his share 1 bigha, 1.5 bighas of land in from 5 bigha, from that number 512 alone, and having sold his share to one Hussein Ali lordship, he had no land. That is what was the finding. But lordship, those purchasers have never been in possession of the land. This is the admitted position, lordship. And they said
No,
that
where is the admission?
admission was that Arfan has land. Your lordship will find it para 3, lordship.
But in para 6, it is stated that Arfan land was sold to Hussein Ali.
Yes,
So
lordship.
he had no land. So he
no
had no
land.
transferable.
They were never in possession. The seller, that is Arfan and his daughter, they had been in possession. Arfan has left for East Pakistan. It was a 1939 land. Now, lordship, they have been there already and their share. At best, lordship, only the purchasers could challenge it if their land has been taken. They had no locus standi. The present respondents have no locus standi. They have got their shares intact, lordship. Merely because that the purchasers did not come to occupy, it does not mean that the property became the property of these plaintiff respondents. That is the crux of the matter, lordship.
What is the substantial question of law?
Substantial
Now,
question.
how the first appellate court decided the matter?
Dittoing the original.
What was the ground taken in the first?
Ground taken was that he had no land. That means seller's father had no land. That was the ground, lordship. No land does not mean. One more thing, lordship, if I am permitted to submit. Lordship, what happens? Their prayer is for cancellation of sale deed. The learned courts bill ought to have been conscionable in considering the fact that the plaintiff, that is the present respondents, claim that their land in Dag number 510 have been taken. That means they were dispossessed from 1 katha and only 1 katha, schedule C, lordship. Page 13, lordship. They claim that schedule B is their suit land. That may be kindly seen, lordship. Page 13, lordship.
Yes.
Schedule B land is the suit land according to them, and they claim altogether, lordship, 2 plots. They claim that 1 bigha 4 lesas are their land. This is one thing. And they, on the other hand, at the next moment, they have claimed that they have been dispossessed from only 1 katha, 1.5 lesas. If that is their loss, lordship, how can they get my sale deed cancelled? This is the admitted position, lordship, for 1.5 bighas. I have purchased 1.5 bigha.
Which includes this 1 katha 10 lechas also.
Yes, lordship. To me. That is the dispute, lordship, where assuming that this includes, but there is a claim, lordship, to be fair enough. They say their land is at 510, and they also at the same time say that I have been allowed to sell from that number 512.
No, this sale deed which was cancelled pertains to which land? 510 or 512?
512.
512. Let us see. Where is the judgment of the trial court?
Lordship.
Trial court's judgment,
Judgment, lordship.
where it has dealt with that issue.
Lordship. Page 18 may kindly the current operator. Issue wise lordship may kindly turn to page 33, lordship. The issue wise decisions starts from them, from their page. First two issues were decided, lordship, so for cause of action and the limitation. Decided in favor of the plaintiff present responsible. Issue number 3, lordship. At page 44, para 41, lordship may kindly turn. While discussing about the procedure for correcting records, etc., lordship. Plaintiff's right title were decided affirmative. At page 47, lordship. That is their lordship. They have their lens, we have no objection. But so far,
This right title and interest was declared over which plot of land, 510 or 512?
according to lordship, the plaintiff pair, it is 510,
510, dark number 510.
lordship. It
And,
is after conversion of KP Patta, lordship. Originally,
and where, what is your land?
my land is lordship in both the tracts. One of my crux was that there was no separation. I was permitted. This is one point. I was permitted to sell. My father was permitted to sell. He sold, but they were no longer there. No longer means it was already always in possession of my father's possession. So
No,
that is
regarding facts, regarding facts,
lordship.
facts. This was dealt with by the first appellate court. Before this,
This is the trial court's decision, lordship, and there is no mention of that. So the matter was not entirely scrutinized, and that was vetoed by the appellate court, lordship. That is what is the problem. And how can my sale deed can be cancelled for 1.5 because of land? If their land involved is only 1 katha, 1.5 lesses. That is the point, lordship.
no, whether on that ground the sale deed was cancelled or the cancellation was on the ground
I
that
had no land, I had
you
no
had
land.
no
Yes,
transferable interest.
Yes, sir.
Arfan Ali had no land at all.
no land at all.
On
No
that
transferable
ground,
interest.
it was cancelled.
Yes, lordship, that is there.
Then where is your case? What is your case?
My case is, lordship, I had been there for quite a long time. This is one thing. And my share, my father's share is intact. My father sold a property, lordship, that does not mean it was not sold to the plaintiff's present respondents. It is not that the property was sold to plaintiffs. This is one point, lordship. And nextly, lordship,
No, it was sold to somebody.
it was
Assuming
sold to somebody.
it was sold to somebody.
The property,
Then your father means Arfan Ali. Who is your father?
Arfan Ali. Seller's father, I mean to say sellers, we have not before the court.
Seller's father. Seller is Daliman.
Seller is Daliman.
Daliman is,
The successor, in fact, who inherited the property.
and you are
I purchased from them.
Hamid and Rukia.
Yes, lordship.
You purchased from Daliman.
Daliman Nasa.
The
Nasa's
The-
father had already left.
now the question is, in the trial, while deciding issue number 4,
Lordship.
The trial court said that as because the predecessor in interest of your purchaser had no transferable right, no land at all.
No land.
So they could not have transferred the land by executing a sale deed. Therefore, sale deed is cancelled.
Lordship.
What was the wrong? There is
Lordship.
an-
Question is the question of locus. Question is the question of locus. My father sold the property. I inherited that property. I inherited means buyers were not there at all. Not there at all. If it were sold to somebody and they did not get, the purchasers ought to have come and challenged my right. Now the present respondents are in no way, have been no way connected in this present property.
No,
They-
no, because the sale deed also involves a portion of land over which some portion of land, 510 in Dag number, therefore their interest was involved.
Yes, Lordship. I agree
Now-
to that point.
Now, what is the substantial question of law? On facts, we will not go. What
Lordship,
sense?
The question of possessory title will again come, Lordship, because the question of locus is also there. Plaintiffs respondents do not have any right to question my right.
Whether this plea was raised before the first appellate court,
First appellate court, that plea was not.
then you cannot raise it now.
No, Lordship.
You
if-
cannot bring it.
Lordship, at some point of time, what happens, Lordship, new pleas can be taken in second appeal if gross injustice is done. Lordship, I may have to seek leave of the honorable court. This is one aspect. But it can be raised if there is in fact miscarriage of justice.
No, this is the third forum.
That is true, Lordship.
What is the substantial question of law which
I
you are,
have got, Lordship, 4 substantial question of law. Yes, 4 substantial question of law. 2 are, Lordship, in fact, the matter pertaining to the court. That is that, Lordship,
which one?
at page 6, Lordship, may kindly see.
Yes.
First 2, I harp on, Lordship. So far, the second and
Which you are pressing?
today, Lordship, substantial question of law can be reconsidered and formulated later on also, Lordship. But so far, at this moment is concerned, Lordship, one is the first point, Lordship. That is the admitted position. I have got different plot of land. They have got different. How can they come for cancellation of sale deed in 512, Lordship? Assuming their claim is that their land is in 510. Nextly, Lordship, decree of ejectment is also improper and grossly erroneous. If they have got one katha, 1.5 lesas of land dispossessed from, then, Lordship, for this, they cannot get my entire sale deed cancelled. They will be the purchasers of Arfan who can challenge my title. The present respondents have no locus standi.
Where is that issue?
Locus standi issue is not there, Lordship. One will, while discussing, Lordship, at the time of argument, one will cover. I suppose, Lordship.
Whether the fathers admittedly legally recognized.
Fathers admittedly and legally recognized title.
Whose fathers?
A fathers, Lordship, it is the present present appellant's seller's type father. My seller's father, Lordship, from whom I purchased. He has got title, admittedly. They could not show any partition to differentiate.
No,
this
no,
land.
but but the trial court held that father has alienated his property earlier also.
That point I have already submitted before your lordship, that if I have, my father has alienated the property, then they are the proper persons, lordship. They are the proper persons to come before the court. They have been deprived from the purchased land. My father has sold the land. Lordship may kindly consider one thing. My father has sold out the land. The buyers do not have any possession or any interest in the property, and I, being the daughter of the seller, I have been there. I have sold. How come these present respondents, lordship, to claim that property, my father's property?
Because the sale deed also involves some part of land over which they have right.
Not lordship, not lordship. They say, lordship may kindly see. Page 10 and 11, as lordship 5, para 5, page 10, last para, lordship.
Yes.
Here, how the pattas and bags were converted during settlement, lordship. Para 5, I do not harp upon, lordship. Para 6, para 10, lordship, at page 11.
Yes.
Para 10, lordship may kindly see that after purchase of the land, the defendants tried to take forcible possession of the suit land, but due to the resistance of the plaintiff, they could not succeed. This is one point. There is a date on which I tried to dispossess, and they say that I could not dispossess. But in the same stroke, lordship, page 12, para 11 of the plaintiff, lordship. Here, lordship may kindly see that in November 2010, after August, lordship, November, say after 3 months, lordship, we forcibly ousted them from 1 katha, 1.5 lesser of land.
Yes, this 1 kotha, 1.5 lecha
Yes, lordship.
is also covered by the sale deed.
Sale deed, lordship, 512. Sale deed, lordship, they say that they have allowed me to sell. Okay, lordship. And I have sold from doc number 512. That means, lordship, it has no connection. My forcible disposition has no connection with the sale deed. We have forcibly dispossessed them, means we are trespassers, we are encroachers in their land. It has in their land in doc number 510. So this land has no connection with 512. Even at the schedule, lordship, schedule C, lordship may kindly see, only 5 references made only of 5, doc number 510. And they have said, I have been asked to sell or allowed to sell doc number 512. If the position is this, lordship, and that too, I have dispossessed them from 1 katha and 1.5 lesser. For this, how can the learned court below, without exercising a judicious mind or holding that I have no land to sell in doc number 510, while plaintiffs admitted land is in number 512.
Where is the sale deed? Have you annexed the sale deed?
Lordship,
Have you annexed the sale deed?
sale deed not annexed, lordship.
Copy
It
of
is in the
sale.
record. However, let me see, lordship. I have got certain copies of documents I may have. Lordship. So this cell deed is Lordship exhibit number 9. Lordship, it says, the cell deed says that it is 510. Another question is that 510.
510,
Lordship.
and the respondent's land is also in 510.
They claim that.
Therefore, they were affected.
That is, they were affected.
Therefore, they challenged.
They were
And
affected.
during the challenge, it was found that your predecessor in interest had no land at all. And on that ground,
500, the property was not partitioned. Lordship. Entire land, there were 6 bighas of land. Lordship. There were 6 bighas of land purchased by my father, my seller's father, and the plaintiff's predecessor in interest.
okay, now tell me the exact substantial question of law which you are facing.
Lordship, the question of unpartitioned may be brought in.
No, you have to,
I cannot say at this stage, Lordship.
but you have to wait. Because the substantial question of law which you have stated in the
Lordship.
memo of appeal does not appear to be applicable.
My father's title is admitted. So far the land is concerned. I have sold or not, or whether they are
My means
my father's means, I mean to say my seller's
father.
father. That's it. That is
Okay.
upfront. Admittedly, I had land. Whether they allowed it or not, my seller's father's title is admitted. In which that, how can they decide, Lordship? And apart from that, Lordship, this cannot be done by them. Plaintiffs cannot decide in which dag I will stay or where I should sell. So they said that they asked me to sell my land in dag number 5.
In whose possession the suit land is there now?
Disposition is the question, Lordship. For disposition of
Now in whose possession the
Lordship.
dag number 510,
They claim 510
in whose possession that said land is now?
in my possession.
In your
Because yes, Lordship, because they want delivery of khas possession. But they can claim delivery of khas possession only when their title is declared in respect of that. And they want cancellation of sale deed. Actually, they made the hotspots of the plain. That is the thing, Lordship. They claim 510 is their land. Okay, Lordship. They said the sale deed should be cancelled. Out of 6 bighas, I do not mention anything, Lordship. I beg to submit that only 1.5 bighas of land. 1.5 bighas of land, they say in their schedule, Lordship may see again. It is 1 bigha, 4 kathas. I have sold 1 bigha, 2 katha, 10 lesa, 12 lesa in the sale, particularly in the sale deed, specifically mentioned, exhibit 9. Then they are claiming they are right in 1 bigha 4 kathas. So further lands are there. Anyway, Lordship, this is their claim. I have sold 1 bigha 2 katha 12 lesas. Next, Lordship, they say that I have dispossessed them. That means in other portions they have possession. If in other portions they have possession out of 1 bigha 4 lesas, Lordship, 4 kathas, I am sorry, very sorry, Lordship. 1 bigha 4 kathas, then Lordship, only 1 katha of land, 1 katha and half lesas, 1 katha, 1.5 lesas of land they have been dispossessed of. According to their claim, Lordship, I am not submitting my case. They must succeed, Lordship, in proving this. And the learned courts below did not consider all those things at all, in spite of admissions, in spite of evidence on record, Lordship. For me, Lordship, this is the crux. Wherefore I am before your lordship.
And what is the substantial question of law?
Substantial question of law, lordship, at least this can be done, that they cannot divide without partition, without proof of
No,
partition.
no.
Lordship.
You have to precisely state that substantial question in your memo of appeal.
I'm sorry, lordship, I could not.
You have to state that substantial question of law in your memo of appeal. You have,
Memo, in memo, lordship, one was that first question, lordship.
but that does not, I am not very much, I am unable to persuade me. And others,
Other questions are of lordship. Without payment of court fee, lordship, no relief can be claimed, no relief can be granted. They have simply in 1 lakh valued the suit at 1 lakh something, and they have paid only, they cannot of their own, beyond law, lordship, fix a court fee and pay.
but that is not, also not a question of law,
Not a question of,
not a substantial question of law.
that's,
That is admitted.
that is lordship. So far reliefs are concerned, then lordship may kindly give me some time to file the press substantial question of law.
Okay. Precise substantial question of law.
For the time being, lordship.
No, if you are
Precise, lordship. Precise, lordship. Just one or two.
heard, Mr. L. Talukdar, Bennett, counsel for the appellant, who praised for allowing him to amend the memo of appeal to bring the precise substantial question of law involved in this second appeal
See, in the form
On
of
record.
affidavit, if I am submitted, allowed to submit.
by, no, you file and you amend your memo of appeal.
Then lordship, I will have to make again one application for amendment. Also, lordship has allowed it. Okay.
I am the, how much time do you want?
Maximum 2 weeks. Lordship.
Let this matter be listed again after 2 weeks. And in the meanwhile, the appellant may submit the amended memo of appeal as desired by him. List accordingly after 2
Because I have
weeks.
to go through the entire records,
After
which I do not possess, lordship. That is why the
After 2 weeks.
obliged. Lordship.
My lord, this matter may be adjourned for the day, my lord. Personal difficulties of the PP does not engage counsel.
Heard Mr. S. Das, learned counsel for the appellant, who submits that due to personal difficulty of the conducting counsel, Mr. P.P. Das, he prays for an adjournment. The prayer is allowed.
The day after tomorrow, my lord.
Let this matter be listed again on 31.
Right.
Day after tomorrow is 31,
Yes, my lord.
31/7.
Right.
2000.
File your blessing.
May I please your lordship? In this case, lordship asks us to find out some authorities, lordship. To that regard, we have charged in several sites, lordship. Even after that, some citations, one citation from Supreme Court and other from Allahabad High Court and other courts also we got. Lordship, in this case, these cases, charge sheet already submitted, then thereafter, this plea was taken and then it was considered, lordship. And one case of Allahabad High Court, lordship,
What was considered? Now, in this case, in the case which is before us, you claim that the contraband is 23 kg plus without excluding the packets.
yes,
And had the weight of packets been excluded, it could have been less than commercial quantity.
yes,
But
Apart from that, lordship, we have one another contention 52A is not complied with as per the Caesar list. In this case, lordship, what happened?
how
Uh,
52A was not complete?
Lordship, I will come to that, lordship. Before that, lordship, kindly turn to page number 17 FIR.
Yes,
FIR, lordship, at the last, after receiving the information, intercepted the house which belongs to Atul Malakar. So, information received from Atul Malakar, then lordship, this house was intercepted. Owner is somebody else. So this person, where they were found, the FIR did not disclose. Then thereafter, what happened after the last paragraph, kindly go through the last paragraph, that during preliminary inquiry, they disclosed their identity regarding this and their names. Immediately a search was conducted in
at page,
page 17, lordship,
17.
FIR, lordship.
yes, during,
uh, During preliminary inquiry, they disclose their identities as like their names and addresses. Then
How-
thereafter, lordship, immediately a search was conducted in presence of available witnesses, namely so and so and so. Then thereafter, lordship, during search, following items, articles and items were recovered and seized accordingly. So 12 numbers of sealed packet wrapped with sellotape, brown color, containing suspected to be ganja, weighing about 32 kg, 0.46.
23 kg.
Sorry, 23 kg, 436 grams. Then two mobile phones. Then last line, the seized 12 numbers sealed packet narcotic substances suspected to ganja were packed and sealed by me in presence of above mentioned witnesses using hardboard cartoon. Or at the spot, he has this officer, Zuel Das. He has already packet seized and packet there with the hardboard cartoon. Then what happened, lordship? If lordship go through the contents of the Caesar list at page 22. Page 22, place from where Caesar. House number so and so so and so. House number 38, Uberun, Hatigaon. Then these packets were recovered with from 1 to 12 with a sealed packet containing suspected to be ganja marked as A1 weighing so and so kg with packet. So these were not differentiated. We'll find it at the second page, page 23. Sealed packets were kept inside the paper cartoon. The cartoon was half sealed. It was under process. The sealed packets were well wrapped. Then in column number 3, weighment have been done at the PO in presence of witnesses and accused. Sample in duplicate have been drawn at the PO in presence of witnesses for FSL examination. So these already done at the PO. So which is contrary to the judgment passed by the Honorable Apex Court in Union of India versus Mohanlal. And and section 52A in contravention of section 52A. So if it is so, in that case, lordship, this benefit is they are going to get at the time of trial, but this benefit will get during the bail also, lordship, because the entire proceeding is going to be vitiated because of non-following this mandatory provision of requirements of section 52A. And if where from it is recovered, it is not cleared by the documents which have been submitted before the court below. And though item, presumably, if we...
no, my question on last occasion was here the sample was
Drawn
Um,
at the spot or
the sample was drawn at the spot as per seizure list,
yes.
but as per the certificate issued by magistrate, sample was drawn in front of him.
So
So when two facts evolve, where sample was also drawn in the seizure at the spot, as well as also drawn before the
no,
magistrate.
that is not clear in their CD on last occasion also. Whether they have collected these samples reopened again before the magistrate and then again it has been collected before the magistrate, that is not cleared in their CD on last occasion, Lordship. So if we believe the seizure list is the first document which they have prepared at the spot. So if we never believe this, then there is no seizure. If we believe this, then 52A is not believable, Lordship. And one more submission with this, Lordship, after going to all the documents, I found that suppose 23 point something recovered. From whose position? It was joint position, that is also not mentioned. Suppose it is recovered from a house and I was inside the house, that is not clear as per FIR and forwarding and all. Forwarding also not clear, Lordship, to that regard. Forwarding is at Lordship, will find.
What is your name? Sadiq.
Sadikul Haq.
24.
24.
24.
Page 24, Lordship, grounds of arrest, kindly see. At page 25. It is not clear that he was in possession of the, or these persons were in possession of that, Lordship. Where the contrabands were concealed. House was, how many rooms were there in that house? In which room it was found? That are not cleared in the forwarding report as well as in the FIR. And a seizure list also did not disclose from whose position.
House belongs to whom?
It is not clear from the these documents, Lordship. These are not the owner of the house, Lordship, because their addresses are different. And they are the 22 years old boy, 19 years old boy, 23 years old boy. And this person is a student of
MBA.
MBA, Lordship. I have the document there. They're going to appear in fourth sem exam, Lordship. Okay. Oh, no.
Okay.
And these are the contrabands recovered, Lordship. The 23 point something. Suppose we segregate between these persons, that will come into the intermediate quantity.
Now, how it will come to
If they can establish that.
what?
If they can suppose equally we divide it, set and then it will more than 7 point something.
No, why equally divided?
Suppose, Lordship, if they can produce, they can establish that regard. Because as per documents, it is, they cannot establish that this was recovered from exclusively from my position or from our joint position. And the documents 52A regarding that, if we believe the seizure list, then we cannot believe the 52A documents comply, they have complied subsequently. If we believe 52A, then we cannot believe this document, Lordship. Because as per last occasion, I have also seen the contraband packets in their CD, Lordship, as per after permission of the Honorable Court, Lordship, that was only in bundle. Whether it is open, because we have handled thousands of cases in the trial court, Lordship. If they follow the procedure, then they have to open all the packets before the magistrate, then they have to collect the samples. This should be in the photograph. How they have maintained the procedure. That is not the CD, Lordship.
Malat, I have to go thoroughly. Now, Malat, first instance, Malat, and on the earlier date, I was not there regarding this technical questions raised. First occasion. And regarding the situation, Malat, that three person, they are called by one another person, Malat, one
Kiram?
Jojo.
Hmm?
one person, another person, this not these three persons. He asked them and provided the contraband mallet and asked them to prepare bundle with sellotape. And they all three persons, mallet, they are habitual, mallet, they are in 160 habitually we are taking ganja. And in their room, first Siddiq and one Halif was there. They call their friend Altaf also. All three met together and they are wrapping the ganja with sellotape. They are not saying regarding hard cardboard, they are not saying. They are wrapping
Who?
the
Accused persons.
accused person. They all together in their, they are a tenant. They are in a rented house. mallet.
Document আছে?
They are wrapping the sellotape, ganja in sellotape and make 12 numbers of bundle. So, Malat, regarding this 52 and all this, Malat, I have to go through thoroughly, Malat. Malat, if otherwise not, Malat, because earlier
So
occasion I was
whether
not
the contraband was seized in wrapped condition,
rep condition, Malat.
As per seizure list, that
no, Mr. Parashar,
My lord,
you have to tell me, first of all, whether 52A was violated or not.
Malat,
Then whether the contraband was seized in wrapped condition.
chill packet containing.
Wrapped condition, then whether the wrapping was open, contraband was taken out.
I'll thoroughly check, Malat.
And one more query. As seizure list mentions that sample was drawn at the spot.
Hmm.
What happened to that sample when it was brought to the magistrate? When the sample was again drawn before the magistrate? That sample which was drawn, whether it was mixed with the contraband and fresh sample was drawn, whether fresh wrapping was
Yes.
done before the magistrate, whether the contraband was weighed independently of the packages,
packet.
without the packages. These answers you have to give. Tomorrow we'll take up. Because tomorrow other council will be making their submissions.
I think other councils, they did not raise this point, Lordship, in
Now
their
Mr.
petition.
Datta will be making NJ Datta. He submits that he has certain submissions. One set of lawyers have made no submissions. They will go by your submissions. It appears, but Mr. Datta on that day submitted that he has something different thing to submit.
The judgment he wants to place, I think, Lordship.
I don't know.
Lordship, on last occasion, in division bench, we have mentioned that judgment passed by the court number 12, honorable court number 12, Lordship.
And whether 52 violation of 52A
Malat, I have
would
written.
give you benefit in bail also. That you
And Lordship, if there the consumer, then it will, section 27 will applicable. Right?
এই সিচুয়েশন একটু র্যাপিং করে আছে না
Then the punishment will be for 6 months.
no, but seizure list shows that it was seized from you,
all 3%.
all three persons.
That is not exclusively mentioned, Lordship, in there, that whether from, I have made this submission, Lordship, where from it was recovered. That is not clear as per the FIR as well as the seizure list. Lordship.
Name of the particulars of the person from whom seized.
It was recovered from house number
How-
38.
Yes, house number 38, whether it is belongs to us or not, no documents is during the investigation.
From this person, I think.
That will be decided in evidence.
But that is correct, Lordship, but it has to mention before the CD also, they can mention in that, and column number 2 of the seizure list, Lordship, it is clear that it is from house number 38. Whether that house belongs to me or not, that is.
Okay, we'll continue tomorrow. Heard Miss S.K. Nargisla. You answer these queries.
My lord,
Heard Miss S.K. Nargisla, counsel for the petitioner, also heard Mr. K.K. Parashar, learned additional public prosecutor. The hearing remain inconclusive. Let this matter be listed again on 30/12/37/2024, along with bail application number. What is in? Along with bail application number 1048/2024.
The authorities, I will suppress tomorrow. Obviously.
Oh, I'll take a short break of.
মই দুই তিনিটামান পেকাই মেডিকেল লগালো এক্সেপশ্যনটো বুজি পাইছো ইমান লিখে অনলি 48 টো আছে যেটো দিলে মই মই কোডত যাব লাগিব 24 to appropriate bench, no? Abdul to Abdul. Abdul to Abdul.
Standing, updated action, item number 48.
May I please, Your Lordship? Your Lordship, this I has been preferred, Your Lordship, to correct the name of the applicant petitioner, Your Lordship. In order dated 24/6/2024 at page number 8, Your Lordship. And further, for the extension of time, Your Lordship, to appear before the trial court, Your Lordship. Here, Your Lordship, my name has been wrongly recorded as Abdul Qasim, Your Lordship, instead of Abu Qasim, Your Lordship, Abdul Qasim, Your Lordship. And on 24
is your name?
2024, Your Lordship, has
Abul
Instead
Qasim.
of Abul Qasim.
Abul Qasim. And Your Lordship has directed me to appear before the special POXO court of Bisnath Charial, Your Lordship. Accordingly, on 28, Your Lordship, I appeared, Your Lordship. I with the intention to appear before the trial court, Your Lordship. I talked to an engaged counsel of the Bisnath Charial bar, Your Lordship. Then he found out the error, Your Lordship. My name was wrongly recorded in the order, Your Lordship. And further, Your Lordship has given me the time of 7 days, Your Lordship. Already expired on 30th/6/2024, Your Lordship.
Ms. G. Bora, Learned Counsel for the applicant. This interlocutory application has been filed by the applicant Abul Qasim, praying for modification of order dated 24/6/2024 passed by this court in AB case number 501/2024. So, Learned Counsel for the applicant has submitted that in the order dated 24/6/2024, whereby interim protection was whereby the applicant was directed to appear before the trial court within 7 days of the date of the said order, the name of the applicant has been wrongly written as Abdul Qasim instead of Abul Qasim. And therefore, he could not appear before the trial court as directed by this trial court as per the directions of this court within the period of 7 days. Stop. On perusal of the record of AB case number 501/2024, it appears that the name of the petitioner has been mentioned in paragraph number in paragraph 2 only, where the name has been mentioned.
Your Lordship, at the prayer portion, Your Lordship. And
No,
again, under
in the
Your
order,
Lordship, 3. Paragraph number 3, Your Lordship. Paragraph
no,
number
you need modification in the order.
Lordship. Paragraph number 3, Your Lordship.
Paragraph number 3, there is no mention about your name.
No, in the order in the name,
In
in the
in-
top,
in in the top, Your Lordship.
name in the case, perhaps they have made a mistake in the petition also because of
Yes,
that.
yes, my petition, Your Lordship.
Or you have
Yes, I have done the mistake, Your Lordship.
Because of the,
Learned Counsel for the petitioner has submitted that due to typographical mistake, she had then, unless this first title is amended, because the order is
it's
not-
not disposed of. I am also
It was
thinking,
disposed of.
disposed of, no?
Disposed of.
Oh,
It was disposed of.
disposed of case,
yeah. Due to inadvertence, the name of the petitioner has been mentioned in the anticipatory bail application filed by the petition applicant as Abdul Qasim instead of Abul Qasim, which caused the error in the order dated 24/6/2024. Stop. Now, how will we know that you are Abul Qasim? You filed an application by name Abdul Qasim. You got bail by the name Abdul Qasim. Now you are coming that I am not Abdul Qasim, I am Abul Qasim. Tomorrow you may come with another plea that I am not. The name should be Rahim Qasim. And merely on your prayer whether the name would be changed.
It was not, it was this appearance, now I apprehend that your lordship, that if my name appears wrongly, your lordship, then because my all relevant documents.
Because name appears wrongly because you mentioned the name wrongly in your,
I mentioned the name wrongly, your lordship.
and that has been disposed of. What is the name of the applicant in the FIR?
In the
Well,
FIR, your lordship.
You are named,
Mohammed Abdul Qasim, your lordship. In the FIR, your lordship.
then
My name was in all relevant documents, your lordship, Abul Qasim, your lordship.
where are those relevant documents?
Those relevant documents. Your lordship, give me some time, your lordship, so that I can drag all these records with this petition, your
Because-
lordship. To this time.
You have to show
Lordship,
that
lordship,
this Abul Qasim is involved in that case.
lordship.
You are, otherwise anybody may come and
Lordship.
say that
In that case, my lord, against, we have to verify in the CD also,
yes.
because he saw.
Because direction
Who is
was-
the father's name, who is the, my lord,
Because there is no error in the order.
No,
bec-
your lordship. It was my mistake.
It was your error.
Yes, your lordship. I have admitted this thing, your lordship. At paragraph number 3, your lordship, I have admitted the fact, your lordship, that I have made the error, your lordship. Inadvertently, your lordship. And it was on 4th, your lordship.
Then you give supporting documents.
Lordship, to this time, your lordship.
You cut it off. Not Ms. G. Bora, learned counsel for the applicant who submits that she may be allowed to some time. She may be allowed to file additional affidavit to bring some documents on record and
First of August.
and for that some time is prayed by learned counsel. The prayer is allowed. Let this case be listed again on
1st of August, your lordship.
1st of August 2020.
Much obliged.
Item number 12, in order.
May I please, your lord? As per last office noted in 28/6, LCR has received. So kindly this matter may be fixed for hearing lordship in the month of August.
Mr.
A. Burua.
K. Burwal, learned counsel for the applicant. Learned counsel for the, this is insurance appeal.
No, it's claimants.
Learned counsel for the appellant. Also heard Mr.
H.
P.
Buragohai.
H. Buragohai. Learned counsel for the
Respondent number 1.
respondent number 1,
Insurance company. Yes.
one insurance company. The record, the concerned record has been received from the Motor Accident Claims Tribunal. And this case is ready for hearing. Hence, the registry shall fix this case for hearing after 4 weeks on a date to be fixed by registry.
Obliged.
Item 13.
May it please your lordship. Your lordship, in this case, service is completed upon the respondents and LCR has been received, your lordship.
Third, Miss P. Bhattakur, learned counsel for the,
Appellant, your lordship.
this I is for,
This is an application under Order 41, Rule 27, your lordship, for adducing additional evidence, your lordship. Lordship, this may be heard at the time of hearing.
when it should be heard. It has to be heard before appeal.
Lordship, may peruse the order dated 15/7/2024, your lordship.
No, at the time of hearing, then it would become,
This,
this
I
has
should
to be
be
disposed of first.
first.
And then only, because order 41 rule 27 petition, unless it is heard, how will we decide that whether we will allow additional evidence or not? So this has to be disposed of. Thereafter, main appeal has to be heard.
So a date may be
Yes,
fixed
your
for the
lordship,
hearing
a
of the
date may be
IAM.
fixed, your lordship, any short date may be given.
In IA eligible, heard Miss P. Bhattakur, learned counsel for the applicant insurance company. Also heard Mr.
Amar Islam.
M.
For
R.
respondent number
Islam, appearing for respondent number
1.
1. Let this, though it appears that by order dated 15/7/2024, it was mentioned that the instant interlocutory application shall be considered at the time of hearing of the connected appeal. However, as this interlocutory application is under Order 41, Rule 27, of the Code of Civil Procedure, same has to be considered before the hearing of main appeal is taken up. Hence, let this interlocutory application be listed again for consideration after 2 weeks on a date to be fixed by registry.
Okay, sir.
I love.
Item number 14.
Lordship, this is a delay petition, Lordship, 23 days. All the respondents are served except Lordship, respondent number 5.
Delay application.
Lordship, delay application, Lordship. Regarding respondent number 5, Lordship, in this case, there are 3 another connected cases, Lordship. In that cases, my learned friend is as Manikor was appearing. So she today informed me that respondent number 5 has expired, Lordship. So we will have to take
Who is respondent number 5?
is Mr. Tonkeshwar Dotto,
No, who is he? Driver,
owner of the
Own-
vehicle, Lordship.
owner, okay.
Yes, owner of the vehicle, Lordship. We are challenging our liability as there was no driving license, Lordship. And some liability was imposed on us.
Then you have to take steps
Yes, to bring their legal errors, Lordship.
on record.
I'm appearing for respondent number 6. There are 2 insurance companies. Respondent number 6, the United India Insurance Company. Lords.
So he will have to serve, inform us the legal errors. We are not aware, Lordship. So who are the legal
You
errors?
take information,
Yes, Lordship.
heard Mr.
What's the case, sir?
A.J. Saikya, learned counsel for the petitioner. Also heard Mr.
H. Buragohai, Lordship.
H. Buragohai appearing for
Respondent number 6.
respondent number 6, as well as
A Burwa for respondent number 1, 2, 3, and 4.
Mr. A. Borwa appearing for respondent number 1, 2, 3, and 4. Learned counsel for the applicant has submitted that he has been informed that the respondent number 6 has respondent number 5 has in the meanwhile passed away. And in view of this said information, he shall have to take steps for bringing on record the legal representatives of respondent number 5 and prays for some more time to take steps for the same. You take steps. I'm not mentioning from where you will collect the names of legal heirs. Who informed you about the,
The council.
in
will-
some other case?
Yes, connected cases. These are also pending in this court, Lordship.
No, but it is not,
She has informed that the death certificate she has asked for.
you collect, I am not reflecting it.
Yeah.
The prayer is allowed. Let this matter be listed again after. How much time is required? 4 weeks.
6, Lordship.
4 weeks. 4 weeks. List accordingly.
I would like to.
Item number 20.
May please, my lord, in this case, my lord, respondent number 2 died, my lord. I have filed 3 applications for substitution of the legal heirs of the respondent number 2, my lord. Notice was issued, my lord. I have taken steps, my lord. But my lord, the notice was not served upon the legal heir of the respondent number 2, my lord. Thereafter, my lord, allowed me to take steps through justice service, my lord. That was not record, my lord.
Thereafter, what happened?
But I have filed affidavit on 29/2023. My lord,
Affidavit is on record,
my lord, receipt is there, my lord.
but where is the affidavit?
My lord, affidavit is not record, my lord.
It is not on record.
Yes, true.
Then this has to come on record. We'll direct registry. Heard Mr.
M. Hussain, my lord.
N. Hussain, learned counsel for the
Applicant, appellant, my lord.
learned counsel for the applicant / appellant. Who submits that in pursuant to the directions of this court by order dated 28/8/2023, the applicant has taken steps for service of notice on the legal heirs of respondent number 2 by Dusty Mode and has effected the service of notice on the said respondents. Stop. Learned counsel for the applicant has also submitted that he has filed an affidavit of compliance on, when have you filed?
29/2023.
29/2023. However, said affidavit is not found on record. Stop. Therefore, the registry is directed to list this case again after 2 weeks after placing the affidavit of compliance filed by the applicant showing the service of notice on the legal heirs of respondent number 2 through Dusty Mode. List after 2 weeks.
My lord, interim is there, my lord. Maybe continue, my lord. In order dated 3/5/2023, already continued.
What interim was granted?
My lord, for staying the operation of judgment of the title suit. My lord, in I number 508, my lord, I. Order is there, my lord, in main case, my lord. Continue order.
The interim order granted earlier shall continue till next date.
Most of the day.
Number 68.
It is a lordship. It is a transfer petition filed by the wife lordship from the district court, the Tinsukia to Dibrugarh. But lordship kindly peruse the order that is 16/5/2024 of passed by the Lavazim court lordship. Here the service upon the sole respondent has been completed. Lordship.
16/4.
16/5/2024.
There is no order on 16/5.
Passed by the Lavazim.
Record to Sarat.
Is there on record?
Which order you are referring?
Lordship, 16/5/2024, Lavazima order, Lavazima court's order, lordship.
Okay.
Is in the record, lordship.
Who is Akash Mujumdar?
Lordship, it reflects its son, respondent's son's letter.
How old he is?
Lordship, while filing this petition, he was 16 years of age
Okay.
at the time of filing this petition, lordship.
Where this is a divorce case
His lordship,
filed by husband. Where?
Tinsukia, Lord, district.
Where do you stay?
I'm staying in Dibrugarh, lordship.
Dibrugarh.
Yes. With my cousin, lordship, and to the original house of the petitioner is Nagaon, but lordship, the petitioner is staying in Dibrugarh. Due to the ongoing treatment of her mother, the petitioner is staying in Dibrugarh. And lordship, since it's been 2017 and the respondent has not been appearing, lordship may also dispose of it.
Miss. What's your name?
Lordship, M. Nirola on behalf of R.S. Mishra. Lordship. My name is not there, lordship.
Miss M.
Nirola.
M. Nirola, Lanet, submitting on behalf of Mr. R.S. Mishra, Lanet, counsel for the petitioner. learned counsel for the petitioner has submitted that by order dated 16/5/2024 passed by the learned Lawajima Court, the notice of the service of notice on the sole respondent was treated to be complete. Stop. I have perused the order of the Lawajima Court as well as the AD card received back with the initials of one Akash on the same. The in view of the order dated 16/5/2025 passed by learned Lawajima Court, the notice issued to the sole respondent is held to be duly served. This case shall be heard ex parte, duly served. Let this case be listed again in admission hearing column after a week. Let us see whether anybody appears or not. After a week, the interim order shall continue till next day.
Lordship, date may be fixed, otherwise this matter will not be listed, since they are not appearing
When do you want?
next week, Lordship. After a week, any date, Lordship?
On 8th
Yes.
August for admission hearing.
Obvious. May it please your Lordship. Lordship, on the last occasion when that matter was listed before the Honorable Court, I had seek time for taking fresh steps upon the respondent. But unfortunately, I was unable to do it because earlier we have taken steps upon the respondent, but a notice has not yet been served, Lordship. So we are trying to contact with our client that whether the respondent address have been changed or not. Because earlier we have taken steps, but till date, no steps have been served upon the respondent.
No, this is a 2017
17 matter,
matter.
Lordship.
Who are you? The insurance company or
No,
the
I'm
claimant?
for the owner of the vehicle, Lordship.
Okay.
So kindly, some time may be granted to us.
Any stay is there?
No,
No.
Lordship, no stays.
Okay, heard Miss, what's your name?
A Bora,
A Bora Learned Counsel for the, what for this interlocutory application is?
this is for delay, Lordship.
Delay condonation. Since last,
Last 17.
if you fail to take step, we will dispose it off by next week. Also heard Miss
P. Huzuri,
P. Hujuri, Learned
For-
Counsel for respondent number
3,
3,
insurance company.
Learned Counsel for the applicant submits that though the applicant was directed by this court to take fresh steps for issuance of notice on respondent number 1, 2, and 4. However, due to why you have not taken?
Earlier we have taken, but the notice was not served. So we are directed to
No.
take fresh steps.
Why have you not taken now?
Because we want to seek instruction from our client that whether the respondent address have been changed to verify that.
Due,
If they're still
due
staying
to,
in the same address, then why it is not being served? And if they have transferred to some
no,
other
no, you
place?
cannot take such plea next time. Because you have been directed, you should have taken these pleas before the court when it directed you to take steps. no such reflection is there that addresses are not proper.
No, that is also there in the ID card, that address is not proper or improper address.
Last line. Due to the fact that the plaintiff, that the applicant could not collect the proper address of the said respondents, and hence prays for some more time to take fresh steps after collecting proper address of the said respondent. Stop. The prayer is allowed. The applicant shall take fresh steps for issuance of notice on respondent number 1, 2, and 4 by registered post with AD as well as by usual mode within 5 days from the date of this order without fail, returnable on 2nd of September 2024. Let this case be listed accordingly.
Item number 18.
None appears for the applicant on call. Let this case be listed again. In the next week on a date to be fixed by registry.
Item 19.
May it please your lordship, here in this case, we were directed to take steps by Dusty Service. We have already informed the insurance. We are yet to receive the Dusty report so that we can file the affidavit, lordship. So I need some 4 weeks time, lordship.
Okay, heard Miss R.D. Majumdar, learned counsel for the applicants. What for this IA is?
That is for delay, lordship.
Okay. Learned counsel for the applicant slash appellant who submits that in pursuant to this court's direction dated 3/1/2024, the applicant has taken fresh steps for issuance of notice on the respondent number 1 through Dusty mode. However, she needs some time to file affidavit of compliance in that regard. The prayer is allowed. Let this matter be listed after 4 weeks.
Highly obliged, lordship.
Item number 20.
May please your lordships. Lordships, on last occasion, the matter was listed on 14/5/2024, and after hearing the parties, this honorable court referred the matter to the Guwahati High Court mediation center. Accordingly, lordships, on 14/6/2024, the matter is settled and the agreement is signed between by the parties.
What is the agreement? Where is the agreement?
Report is there, lordships.
No, it is there. Where is the report?
What
Report
in
is
file?
not there, wrong.
One photocopy, my lord, supplied to the claimant, my lord, the sole respondent,
Show me the
that is in my
photocopy.
hand, my lord.
What was agreed?
Both are agreed. And settle the matter in a tune of rupees 14 lakhs.
14 lakhs.
Who is the insurance company?
I am for the insurance company, Lordship.
You agree to the,
Yes, Lordship.
it can be disposed of in terms of the.
Yes, yes, Lord.
Heard Mr. What is your name?
NM Dr. Lordship.
Heard Mr. N.M. Datta, learned counsel for the appellant insurance company. Also heard Mr. B. Islam,
Well,
learned counsel for respondent number 1. It is submitted at bar that this case was referred to Guwahati High Court Mediation Center for mediation, and the matter has been amicably settled between the parties during mediation, and an agreement dated 14/6/2024 has also been executed between the parties in terms of the settlement arrived at during the mediation. Stop. I have perused the report of the Secretary, Guwahati High Court Mediation Center, which states that the mediation between the parties has been successful, and the parties to this appeal have agreed to terms and conditions for settlement of the dispute as mentioned in the mediation agreement dated 14/6/2024, wherein it has been agreed between the parties that total settlement value of the case stands at rupees 23,76,500 only, and the additional amount of 14 lakhs shall be paid by the appellant to the respondent within a period of 90 days from the date of signing of the mediation agreement by depositing the said amount before the registry of this court. Stop. In view of the amicable settlement reached between the parties during the mediation, this appeal is disposed of in terms of the said amicable settlement agreed between the parties and as reflected in the mediation agreement dated 14/6/2024. The respondent shall pay the How much you have to pay now?
14 lakhs.
14 lakhs only.
Yes.
Respondent, and what happened to remaining?
Remaining lordships, 9,76,500 has already been
Already
deposited.
been deposited.
Deposited.
Okay. As the respondent has already deposited rupees 9,76,500 before the registry of this court, the remaining amount of 14 lakhs shall be deposited by the respondent to the registry of this court before lapse of 90 days from 14/6/2024. This appeal is accordingly disposed of.
Lordships, statutory amount of rupees 25,000 has been deposited, so we may be allowed to.
The respondent insurance company is allowed to receive back the statutory deposit of rupees. No, you are the appellant.
Yes, Lordship.
Paid by the respondent, or paid by, shall be paid by the, फिर से पढ़िए तो थोड़ा. Respondent, no, appellant. You are the appellant.
Yes, Lordship.
Appellant. 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 To the respondent number,
Respondent one only.
respondent number one,
Claimant.
claimant. The appellant insurance company. The appellant insurance company is allowed to receive back the statutory deposit of 25,000, which was deposited by the appellant at the time of filing of the instant appeal. The registry shall refund the said appeal to the appellant after proper verification.
But on the very day of settlement, my lord, excluding the all amount only in the tune of rupees 14 lakhs that mediation was settlement.
Now,
Only 14 lakhs, madam.
no, that is the order. Only 14 lakhs you will get.
Okay.
Obliged.
Item 21.
Develop.
May it please your lordship. Lordship, the additional affidavit is filed for to show thus the lordship, that is at 5X. Lordship. We have filed our affidavit.
On whom the notices were served?
Opposite party number 2, lordship.
Who is opposite party number 2?
Opposite party number 2 is the owner of the vehicle, lordship. Because he is important, lordship, because our appeal is on about the accident itself. We have alleged fraud, lordship, of concocted false story. So he is necessary party, lordship. That's why we missed that.
How you have served?
Lordship, the report is annexed, lordship.
No, have you obtained the signatures?
Yes, Lordship, down below and also the phone number.
Heard Miss R. D. Majumdar, learned counsel for the. What is this? This I is for condonation.
Condonation of delay, Lordship.
Heard Miss I. R. D. Majumdar, learned counsel for the applicant. Also heard Mr.
M. Swakya,
M. Soikia, learned counsel for, who is respondent number one?
Claimant, Lordship.
Respondent number one. Learned counsel for the applicant has submitted that the applicant has served the notice on the respondent number two by dusty mode, and in compliance of the same, an affidavit has an additional affidavit has been filed by the applicant to show the service of notice on the respondent number two, Mohammed Farooq Hussain, through dusty mode. I have perused the additional affidavit filed by the applicant, which contains a copy of the notice issued to the respondent number two, wherein the signatures and phone numbers of respondent number two also appears. In view of the averments made in the additional affidavit by the applicant, the notice issued to respondent number two is held to be duly served. Then what?
Then Lordship, the delay petition will, and three also serve Lordship, office note dated, sorry, Lordship will peruse, office note dated 22/11/23. Respondent three has received it personally. So the service is complete. Lordship may take up the delay condonation petition, Lordship.
Delay condonation may be accepted, Lordship, only ground that, Lordship. Please be issued direction to deposit 50% of awarded amount, Lordship, by mandatory of provision 173 subclause 1 and 2, your Lordship.
Lordship, delay
50%.
in delay condonation, there is no question of deposit. Only
Lordship,
when the
delay condonation may be accepted, and Lordship, appeal may be accepted, Lordship, admitted. Only ground that, Lordship,
much
50% deposit amount, awarded amount, Lordship, may be
But
deposited
the Lordship.
before the
delay
register of
there
this
cannot be any
document.
condition, Lordship. Either delay is condoned or not condoned,
Yes,
Lordship.
Lordship. We have not any objection, Lordship, if Lordship delay had been condoned, Lordship.
Fine, Lordship. Then,
And
okay,
Lordship, only ground that, Lordship, 50% amount.
No, if
Lordship.
they go for stay of execution,
Yes, then
only then we will direct deposit of 50%.
And we have filed a stay petition also,
It's
but
stay-
it will go stepwise,
In
Lordship.
stay petition, that order may be passed.
Yes,
Not
Lordship.
immediate.
Delay.
How much delay was there?
212 days, Lordship.
12 days.
Stop. As the service, what was the last name? As the service of on opposite parties is complete, service of notice on opposite parties is complete, this interlocutory application may be heard. This application can be a
Explanations, Lordship, I have mentioned in paragraph 3 to 12, Lordship. Because the knowledge itself was after 230 days. When the copy was received from the court, Lordship.
This application under second proviso to section 173 of the MV Act, 1988 has been filed by the applicant for condoning the delay of 212 days in preferring the connected appeal against the impugned judgment and award dated 26/2017, passed by the Motor Accident Claims Tribunal, Nagaon, in MEC case number 414/2012. Learned counsel for the applicant has submitted that the applicant has explained the cause for delay in preferring the connected appeal in paragraph number
3 to 11, Lordship.
3 to 11 of the condonation of delay application. Stop. Learned. On the other hand, learned counsel for the claimant respondent. Claimant/respondent number 1 has submitted that he has no objection if the delay in preferring the connected appeal is condoned by this court. In view of the grounds mentioned in paragraph number 3 to 11 of the condonation of delay application, as well as in view of the fact that the respondent number 1 has not opposed the condonation of delay application, this court is inclined to condone the delay of 212 days caused by the appellant in preferring the connected appeal. Stop. This condonation of this interlocutory application is accordingly allowed. This registration has already been allowed, and the delay in filing the connected MAC appeal is hereby condoned. Stop. In MAC appeal 372, already it has been registered.
Registered, it may come for admission next week, Lordship.
We will admit it today itself.
Oh. Then
It
I'll-
is listed or not?
it is not listed.
It is listed.
Okay. Then Lordship, for that, I think because I'm alleging fraud, Lordship will have to, I do not have the citations.
But
I can
Lordship, the appeal petition is not available with me, Lordship. They
because
must
it
not
did
served to me, Lordship. Yet.
because it did not come for
Yes,
admission.
admission is yes, Lordship.
Okay, let the connected in delay in the condonation of delay application itself. Let the connected appeal be listed for admission hearing column in the next week on a date to be fixed by registry.
Appeal
I'll
may
apply.
be served.
Okay. I have a phone number.
Okay.
Apply. Phone number.
Supreme Court full bench judgment that is reported in AR 1957 Supreme Court 540 para 23. The right of appeal or admission right of appeal is statutory right. It is between the court and the litigant. 1957. Thereafter, Lordship, this judgment has been interpreted in various judgments subsequently by the Supreme Court and the High Court. And there is a judgment of this court regarding, Lordship, the stay matter. Only in the appeal is the right between the court and the litigant and the appellant, and the statutory right, and the matter of stay only it should be heard. That is, Lordship. Para 23, Lordship. The long judgment, I have not taken 2 copies, Lordship. The Supreme Court judgment 57.
heard. The delay has been condoned.
Delay has been condoned long back.
This is item number 7.
7, Lordship.
Who is appearing for someone?
Respondent claimant has appeared, Lordship. He has appeared. I will give you a copy, extra copy, Lordship. Lordship has shown his name also. He has appeared also. Now he is not appearing.
Heard Mr. S.K. Goswami, learned counsel for the appellant. Also heard Mr. A.N. Ahmed, learned counsel for the
Respondent number 1.
respondent number 1. This appeal under section 173 of the Motor Vehicles Act 1988 has been referred by the appellant insurance company, impugning the judgment and award dated 22/12/2017 passed by the Motor Accident Claims Tribunal Bajali in MSC case number 25/2017. You are challenging what?
I am challenging, Lordship will find page 13. Appellant admittedly is a retired government servant. His age has been considered as 55 years, but he is more than 64 years as per identity card.
Quantum.
Quantum.
Okay.
Para 13, Lordship, page 13. Lordship will find it 11 portion. Consider postmortem report. Exhibit 2, Lordship, got it.
Okay.
Page 13 of the appeal minute. In the postmortem report, where the age
No,
of the
okay, okay, not necessary. Issue notice to respondent number 2 and 3 by stop. Since respondent number 1 has already since respondent number 1 has already appeared, issue notice to respondent number 2 and 3. The appellant shall take steps for issuance of notice on respondent number 2 and 3 by registered post with AD, as well as by usual mode within 7 days from the date of this order, returnable on 2nd of September 2024. This appeal is admitted. Stop. Call for the record of MSC case number 25/2017 from the concerned tribunal. The registry to take steps for issuance of for requisitioning the aforesaid case record.
Lordship, we have a stay petition, we will deposit 50% of the amount.
Stay petition is there.
Lordship. And maybe they also release also, Lordship, in favor of the claimant.
The quantum will not come down less than 50%.
No, 50% will deposit.
Okay.
Already,
No, no,
already 25,000 deposited a statutory amount, and total amount was 16 lakhs and odd. Will deposit 50%. And claimant is entitled to the total amount. I have calculated. It is around 10 lakhs.
What would be the 50%?
Lordship, 19 lakhs, 59,188. It may 10 lakhs, Lordship. Almost 10 lakhs.
No, assuming that your appeal is allowed,
He will get 11 lakhs.
then he will get 11.
11 lakhs.
Okay.
It will be automatically allowed, Lordship. It's admitted facts that the age of the is 63 years.
Okay. Heard Mr. S.K. Goswami, learned counsel for the applicant. Also heard Mr. A.N. Ahmed, learned counsel for respondent number 1. This application.
Lordship, stay petition owner and driver is not necessary because policy is not under challenge. Only quantum. We will deposit 50%.
This
Stay petition will be disposed of.
application under this application has been filed by the applicant/appellant, praying for staying the execution of judgment and award dated 22/12/2017 passed by the Motor Accident Claims Tribunal Bajali in MSC case number 2017. The learned counsel for the appellant has submitted that the applicant has referred a connected appeal which has been registered as MAC appeal number 287/2024, wherein the appellant has challenged the quantum of the compensation awarded to the claimant in MAC case number 25/2017 by the concerned tribunal. Considering the grounds taken by the learned counsel for the grounds mentioned by the learned counsel, mentioned by the applicant in the stay petition, the judgment and award dated 22/12/2017 passed by the Motor Accident Claims Tribunal Bajali in MAC case number 25/17 is hereby stayed during the pendency of the MAC appeal number 287/2024, subject to the condition that the applicant/appellant shall deposit 50% of the awarded amount to the registry of this court within a period of
6 weeks.
6 weeks from the date of this order. On such deposit, the claimant/respondent number 1 shall be at liberty to receive the said amount from the registry
On proper identification.
of this court after proper verification. This as for disposal of this interlocutory application, the presence of respondent opposite party number 2 and 3 may not be is not required. Notice to them is hereby dispensed with. This interlocutory application is accordingly disposed of.
Obliged.
May it please your lordship. So we have taken steps against the respondent, the plaintiff, your lordship. But there's a service report, your lordship, of the process server that the notice could not be served because the respondent was not found in that address. So may be allowed to take service by way of Dusty, your lordship.
Lord Mr. H. Buragai, learned counsel for the appellant, insurance company.
Not lordship, the defendant, your lordship. The plaintiff, your lordship.
No, just a minute. Oh, this is CRP.
CRPIO, your lordship.
Okay. You are petitioner,
I'm the petitioner plaintiff, your lordship.
learned counsel, Mr. H. Buragai, learned counsel for the petitioner, who submits, also heard Mr.
D. Chaudhary for the
D.
respondent number
D. Chaudhary appearing for the respondent number
2.
2. Learned counsel for the stop. On perusal of the office note dated 4/7/2024, it appears that the notices issued to the respondent number 1 could not be served as the said respondent was not found in the address given in the notice. In view of the whether he resides in this address.
He is my neighbor, your lordship.
Okay, learned counsel for the petitioner has submitted that the respondent number 1 is the neighbor of the petitioner and he resides in the address given in the notice. Hence, he may be allowed to take steps for service of notice on the respondent number 1 through Dasti mode. The prayer is allowed. The petitioner shall take steps within 3 days from the date of this order, returnable on 2nd of September 2024. After serving the notice through Dasti mode, the petitioner shall submit an affidavit of compliance to that effect before the next date fix. Let this case be listed accordingly on 2nd of September.
Deeply obliged.
May it please your lordship.
My lord, in this case, my lord, one of my associate, N. Ahmed is the conducting advocate. And for his urgent requirement, he had to go Delhi. And he requested me to appear and he is to, as per earlier order, he is to furnish the information about the legal heirs of respondent number 1. My lord, he requested me to pay for one adjournment, my lord. He will come and he will furnish the reports. My lord.
Lord Mr.
A.R. Sikdar.
A.R. Sikdar, submitting on behalf of Mr. N. Ahmed, learned counsel for the appellant.
I'm not appellant, I am respondent.
For respondent. No, you are for respondent.
Yes, ma'am.
You are also in this case.
My name, I don't know, my lord. My name is not shown in the copy.
You are for respondent number?
My lord, my associate, Ayan Ahmed appearing in this case.
Yes, you are not appearing.
I am not, so far my
Yes,
information, I am not in the case.
therefore I was right.
My lord.
Submitting on behalf of Mr. N. Ahmed. Appearing on behalf of respondent number 2, 3, 5, 6, 8, 14, 16, and 23. Who submits that he may be allowed some more time for furnishing the details of the legal heirs of respondent number 2 who has expired. Respondent number 1 has expired. Respondent number 1 who had expired. Stop. The prayer is allowed. Stop. None has appeared for the appellant on call. Please this matter after 4 weeks.
Deeply obliged.
29.
May I please, my lord? My lord, in this matter, we have been recently engaged, newly engaged, so.
Newly engaged for respondent.
For appellant.
Okay.
I'm
So we need
appearing for the respondent, sole respondent. The insurance company.
What is your prayer?
We need some time to file wakalat.
Okay. Heard Miss, what is your name?
M. Bharati.
M. Bharati, who submits that she has been newly engaged in this case by the appellant and needs some time to submit her wakalatnama in this case.
She is
Also,
appearing on behalf of my senior, B.R. Das.
okay. Also heard Mr.
PM Talukdar.
PM Talukdar, learned counsel for respondent number,
Sole respondent.
sole respondent.
The insurance company.
It appears from from record, it appears from the office note that the record of the MSC case number
107 of
107 slash how much? 107/2014 has already been received by the registry. Stop. Let this case be listed for hearing after 4 weeks on a date to be fixed by registry. In the meanwhile, the newly engaged counsel for the appellant may submit their wakalatnama list accordingly.
Your Lordship, it's an application for condonation of delays. Today we are here affidavit. But the matter is that the case has been represented by attorney holder who died in 21/10/2023. Thereafter, no contact has been made with the appellant Santa Devi Dwala. So we need some more time to contact her.
Who is the principal appellant?
Shanti Devi
Shanti
Dwala.
Devi Gwala.
Yeah.
You are unable to contact her.
Yeah. She stays in, we are supposed in Kokrajhar.
Heard, Mr. What is your name?
J. Hussain.
J. Hussain, learned counsel for the appellant. Also heard Mr.
I'm for respondent number 1, A. Ali, on behalf of MJ Borua.
A. Ali appearing on behalf of MJ Barua for respondent number 1. Learned counsel for the appellant submits that the appellant could not contact, the counsel for the appellant could not contact the applicant. This is delay condonation.
Yeah.
Applicant Srimati Shanti Devi Gwala and therefore could not file the wakalatnama on behalf of the applicant Shanti Devi Gwala and need and prays for some more time for doing so. The prayer is allowed. Let this matter be listed again after 4 weeks.
Item 28.
Maybe the Lordship, in this case, that service is complete, my lord. LCR has not been received. Respondent have appeared. So respondent.
Heard Mr.
A. N. Sharma.
A. N. Sharma, learned counsel for the appellant. Also heard Mr.
R. Dwara.
R. Dwara.
Dwara.
R. Dwara, learned counsel for the respondent number.
Sole respondent. Sole respondent.
Learned counsel for the sole respondent. On perusal of the office note, it appears that the record of MSC case number 917/2016 has not yet been received by the registry. Stop. Issue reminder for the same. Registry to issue reminder. Let this matter be again listed after 4 weeks.
Lordship, an extra copy may be served to us. Also.
Okay, no orders, he will serve.
Same order, my lord. Same.
And the records have been received.
The LCR is not received, my lord.
Same order.
Same order, my lord.
Only the Case,
Case number is
MEC
different.
case number is will be different.
919 of
MEC case number would be MEC case number
9, my lord.
919 of
Stroke of 2016, my lord.
of 2016. Baki eke thaki.
Big.
Your Lordship, I am appearing for respondent number 1, United India Insurance Company.
None appears for the appellant on call. Mr. S. Datta, learned counsel for the respondent number 1 is present. The notices issued to respondent number 2, 3, and 4 has not been received by the registry. Hence, await service report. The record of MEC case number 2117/2017 has been received by the concerned tribunal, from the concerned tribunal. Tag the same with this appeal. Release this matter again after 4 weeks.
Major.
May it please your lordship. Lordship, in this matter, we have newly engaged Mr. James Ayala will lead this matter. And we,
Or
for the petitioner. So we have just received the records from the earlier council. And there's some defect in the IA, so we will need some time to get proper instructions from the earlier council.
what this I is for?
This IA is for change of address for respondent number 1. However, the new address has not been stated in this IA, lordship.
Okay.
So we need some time to take instructions from the earlier council.
Heard miss, what is it?
The lordship.
STOD, learned counsel for the heard miss STOD who submits that she has been newly engaged by the petitioner. Your wakalatnama is there.
Mr. GM Sahibala, my senior, will lead the matter.
Oh.
His name is there, lordship. However, we will also file one wakalatnama with other advocates. We need
You have
some
to
time
file
for the
wakalat.
wakalatnama also, as well as for the correct records also.
Okay. And she needs some time for filing wakalatnama in this case. The prayer is allowed. Also heard Mr.
C. Gogoi, your lordship.
C.
For
Gogoi.
respondent number 2.
Appearing for respondent number 2. The prayer is allowed. Let this matter be listed. How much time you want?
Lordship, at least 2 to 2 weeks, lordship.
Let this matter be listed again after 2 weeks. Same order in main CRP case number. A single order code, no? Duta photocopy. Let this matter be listed after 2 weeks.
Obliged, lordship.
Atithi lordship, we have filed lordship for petition for condonation of delay lordship. Whether my friend will file a reply or if he file reply, then lordship, I will not agree. If he will not reply, then I will argue the case.
Lordship, as per the last order passed by the Honorable Guwahati High Court, we were supposed to file an objection and we were given a liberty to file the objection within 4 weeks' time. But however, repeatedly trying to intimate the same to the council, we were not provided with the copy of the IA and the MFA. Repeatedly, we have tried and we were denied to provide the same.
Copy, you have
Lordship,
not.
I will provide lordship, because notice was not issued lordship. We are not providing.
Lordship, as per
No,
the,
how will he file
Lordship,
his
we will
reply
provide.
unless you
We will provide.
it was
provide it
implied-
today itself?
We will
Lord-
provide. We will provide.
Lordship, I would like to place my objection orally. I am very much well prepared with
He
the
can
matter.
place it, lordship. He can place. I also agree with lordship. He can place it, lordship. He can place it.
No, he is submitting, he is
He thinks
objecting.
that he is well prepared for Agu orally, lordship.
No, he is not saying so.
Yes, Lordship, I am very much well prepared for the to argue this matter presently in regard to condonation of the matter. And Lordship, as per the judgment passed by the Honorable Guwahati High Court in Catena of Judgments, in the case of Jasiruddin Talukdar versus Union of
No,
India,
you are saying that you have not received the
copy of the IA.
file.
Yes, Lordship, but law is
Then-
very much clear in regard to condonation of matter in railway matters. In as per section 23, the appeal has to be filed, but there is no provision for condoning the delay. And the same has been observed by the Honorable Guwahati High Court in the case of Jasiruddin Talukdar. And apart from that, Honorable
Section 5 is not applicable.
not applicable, my lord. I would just like to place reliance and I would like to place
Then
the same.
Lordship, there is a contrary view from the defined high court. Even that particular judgment was thrown to the apex court, Lordship. Apex court at present status is maintained in the apex court judgment, Lordship. As the order of status quo.
Lordship, Honorable Guwahati High Court, in 7 judgments I can place. I have brought 7 judgments right now. In all the 7
You
judgments,
file a written objection. You are intending to file a written objection.
Lordship, I would like to prefer and like to give my objection orally.
Oral. Then you make your submissions.
Then Lordship, he says that at first he submit, Lordship. My case is that, Lordship.
No, you are the petitioner.
I am the petitioner, so I am submitting that, Lordship. The law of section 5 is applicable in this petition, Lordship. Even
What
Lordship.
is the matter? How much delay is there? You have to say everything.
Lordship, Lordship, Lordship.
I have not gone through the petition.
Lordship. Lordship. Lordship, I paid little accommodation for today, Lordship. The limitation petition is not there. I am supposed that he will file a. So Lordship, tomorrow, Lordship may fix it, Lordship, I can argue with Lordship. Tomorrow.
Lordship, I would just like to submit, I have placed before your Lordship 7 judgment passed by the Honorable Guwahati High Court. And Lordship, it is very pertinent to mention
No,
that.
no. First we have to decide whether, are you ready?
Lordship, today I am extremely sorry, limitation petition is not here, Lordship.
Is not with you.
No. I suppose, Lordship, he will file a reply, that's why, Lordship.
Then you have. Then let us
Lordship,
fix it tomorrow.
If, much obliged. Lordship, kindly you can.
Lordship, on Friday, Lordship, Friday.
Lordship,
Tomorrow,
can
Lordship,
Don't fluctuate.
I am
Don't
not
make-
fluctuating, Lordship. Even Lordship, he can argue without the petition, Lordship. He can want to argue, Lordship. I will place the case without the petition also, Lordship.
How,
Tomorrow, Lordship, to 3 more
Lo-
part matters in the court number 1, Lordship.
Yes,
That's why I'm
Lordship,
saying.
and also I am having one matter.
Lordship, this is a application filed by us, Lordship. There is no space operating, Lordship. The condonation of delay, Lordship. There is no bar for the petitioner to file execution petition, Lordship. This is a petition filed by us, Lordship. Urgency from our part, Lordship, not his part.
Lordship, as per the law is very settled, even High Court cannot delay 1 day,
Even, Lordship,
condone
our
1
High
day
Court-
of
one-
delay.
One judgment
No,
of our High
I'm
Court,
not
Lordship.
going to hear.
One judgment of our High Court, Lordship.
I'm not going to hear you in this manner.
Lordship.
You have,
Lordship.
you have to maintain the decorum.
Lordship. Our High Court judgment, one judgment is there, Lordship.
Uh,
Now, my friend is repeating, that's why I am calling.
Third, Mr. What is your name?
Divyansh Rathi.
Heard Mr. K. Gogoi,
Lordship,
learned counsel for the applicant. And also heard Mr. Divyansh Rathi, learned counsel for the opposite party. The counsel for the opposite party has submitted that he has not been furnished the copy of the interlocutory application or the memo of appeal filed by the petitioner. The counsel for the petitioner is directed to furnish the same
By tomorrow, Lordship.
by tomorrow. Let this matter be listed again.
Lordship, kindly provide a short date. It can be
You
disposed of.
suggested it.
Lordship, tomorrow only. I am very much well prepared. Even I am prepared today. I can argue it tomorrow as well. Or maximum by day after tomorrow, if your Lordship may please.
Is it okay? Yeah.
Lordship, Lordship, I have no issue.
On 31st of July, 2024.
Much obliged, my lord. Much obliged.
Oblige, Lordship.
ये रिकॉर्ड ये केस बिलक घुराई देंगे.
Wait.
Yes.
May it please your lordship. Lordship will peruse office note dated 25/24 lordship. Unserved notice for R1 insufficient address, but lordship, someone is appearing for R1, Mr. MJ Gogoi. And for R3 lordship received back with no postal remark, but AD card has not yet come. So lordship, we can wait for the service report for some more time. Or else the registry can verify if before the Lawajima, if the service is complete, lordship, by the report.
Okay.
Uh,
Heard Miss R.D. Majumdar, learned counsel for the appellant on though the name of Mr. S. Khan. This is item number?
Item number 35, lordship.
No, nobody's name has been shown.
But that's why I'm submitting, lordship. MJ Gogoi, his name, registry may show the name of the counsel who has filed wakalatnama. There is there.
He has filed wakalatnama.
Yes, lordship. He appeared because they have filed application also. For impleading the mother of the Sona Das as in IA number 1414, lordship, 2024. Lordship will peruse IA number that he has filed, and this was allowed also.
On perusal of the office note, it appears that the unserved notice issued to respondent number 1 has been received back with the postal endorsement within inverted comma insufficient address. And the unserved notice to respondent number 3 has been received back without any postal remark. The AD card of the notices issued to respondent number 2 has not yet been received. As regards respondent number 3, you have to take steps.
Yes, lordship. It has come back without any
Endorsement.
endorsement.
So you have to stop learned counsel.
Just checking the address. If it is from here, lordship, we can do dusty service
Learned
also.
counsel for the applicant. Appellant has submitted that.
We can do dusty service on 2 and 3, lordship. That will be easier.
And one who is appearing, what?
One, lordship, this actually, this J. Gogoi, lordship, he is appearing. His wakalatnama is there, lordship, because he filed the IA number 1414 for impleadment of Sona Das, who is the mother of Anup Das, the claimant, lordship. And that was allowed. I think his wakalatnama is there only. So maybe that's why the registry has not. And this application was allowed, lordship.
No, from wakalatnama, it is not clear for whom he is appearing. We'll wait. If
Actually, I didn't write his phone number, otherwise I would have called him. Anyway, we can wait, lordship. And for 2 and 3, we can take dusty service, lordship. That will be easier. Otherwise, they do not appear, lordship. Owner and driver.
learned counsel for the appellant has submitted that the Mr. N.J. Gogoi had appeared for respondent number 1 in connected interlocutory application number 1414/2024. However, as his name has not been shown in the cause list against the said case. Perhaps he was not aware of the listing above of the said case. Hence, she requests that registry may be directed to show the name of the Mr. N.J. Gogoi as an engaged counsel for respondent number 1 in this case. The prayer is allowed. The registry is directed to reflect the name of Mr. N.J. Gogoi as counsel, as engaged counsel for respondent number 1 in this case henceforth. As regards respondent number 2 and 3 are concerned, learned counsel for the appellant has submitted that the appellant may be allowed to take steps for issuance of notice on the aforesaid respondents by way of Dasti. Stop. The prayer is allowed. The appellant shall take steps accordingly within a week from the date of this order. Stop. The notice are returnable on 2nd September. Notices are returnable on 2nd September 2024. On the next date fixed, the appellant shall furnish an affidavit of compliance regarding the service of notice through the STIMO list accordingly.
Hello, Black.
Wait, please, your lordship. This IA is for injunction, lordship.
Injunction.
Already status quo was granted and they have filed their written objection, lordship.
My lord, learned counsel for respondent out of station. So
That order can be continued or?
Status quo is there.
Yes, lordship.
Heard Miss R. Chaudhary, learned counsel for the applicant in IA. Also heard Mr.
H.A. Rashid on behalf of DCC Pukon.
H.A. Rashid submitting on behalf of DCC Pukon, learned counsel for the opposite parties who prays for an adjournment on the ground that the engaged counsel for the opposite party is out of station. Stop. Considering the grounds mentioned by the counsel, the prayer is allowed. Let this, for what the main RSA's fix.
Lordship, on 29/9/2023, there is an order that till next date, no further construction over C scheduled land. That may kindly be, lordship,
Okay.
continue.
No, but for what?
And in
the
RSA,
ma-
lordship,
main,
RSA, whether they are appearing for all the respondents or not, I have not gone through the office note, lordship. Otherwise, the RSA was already admitted on 5/8/2022, maybe.
whether the trial court record has been received.
Trial court record may be received,
No.
lordship. I have not gone through the office note.
Let
lordship,
this
as-
case be listed after 4 weeks.
Lordship.
The interim order granted earlier shall continue. No, the state. What is
Interim-
the, what
Interim
is
order
the,
dated 29/9/2023.
the interim order dated 29/9/2023 shall continue. No, it is, order has been already passed earlier. That the interim order earlier shall continue till
Yes, lordship.
disposal of the,
Original order is dated 29/9.
disposal of the miscellaneous application. So no further extension is required.
Okay, lordship.
On last date,
order I had not. gone
last
through.
date, it was-
21/6, lordship.
yes, that the interim order passed earlier shall continue till disposal of the miscellaneous application. So no further application.
Lordship.
List accordingly after 4 weeks. In main RSA,
I will say office note we have not seen today, lordship, as IA was listed for consideration. Lordship may take it after some time. I can go through the RSA lordship office notes.
no LCR we have not received.
Okay.
So will
Then
he issue
trial
requisite?
court reminder make application.
Heard Miss R. Chaudhary, learned counsel for the appellant.
Yes, Lordship.
Also heard Mr.
H. Rashid.
H. Rashid appearing for
DC
Mr. DCC Fukan, learned counsel for respondent number
1 to 8 method.
1 to 8.
All the respect.
From the office note dated 25/20/24, it appears that the trial court record has not yet been received. Issue reminder for the same, registry to issue reminder. Let this case be listed again after 4 weeks.
I'm deeply obliged.
Lordship, I am for respondent number 1, Oriental Insurance Company.
This I is for condonation of delay.
Delay, Lordship.
You are opposing.
Yes, Lordship. Kindly allow me some time for filing objection.
None appears for the petitioner on call.
I'm also appearing behalf of DCC.
Who is the
37.
27?
Yes,
Heard Mr. S. What?
H. Rashid, my lord.
Heard Mr. H. A. Rashid, learned counsel appearing for Mr. DCC Fukon, learned counsel for the applicant. But DCC Fukon's name is not there. In this case. Mr. R.C. Paul.
I'm on behalf of R.C. Paul.
Mr.
A.R. Das.
A.R. Das appearing on behalf of Mr. R.C. Paul, learned counsel for respondent number 1, seeks some time for filing written objection against the prayer for condonation of delay made by the applicant. The prayer is allowed. Let this matter be listed again after 2 weeks. In the meanwhile, the respondent shall file the written objection with a copy of same furnished to the applicant. List after 2 weeks.
Much okay.
Number 98 and 99.
In item number 38, I filed one application, for deposition of 50% of the awarded amount. It was a dead case,
In this case,
claimant is, here, the mother of the deceased, 4,20,000 only given, Out of them, I pray for withdrawal of 50% after the claimant, But at the time of interim order, the admission.
You are for?
I am for the claimant,
I'm for the insurance company, Lordship.
You have deposited
Not
50%.
Order was not there.
There is no order, Lordship.
There is no order.
Yes,
For what this?
Actually, the order is not there because, Lordship, we have filed approaches by filing this appeal. That's because there is no driving license of the driver, Lordship.
No, was there.
Yes, Lordship. Yeah. Again, that's why, Lordship, there is no order of deposition of the.
No, whether the impugned award and judgment has been stayed.
Yes,
State,
Lordship. State, Lordship.
Page 10. I have
But
next-
no order for deposition of the 50%. As because Lordship, we have challenged the judgment on the ground of that at the time of accident, the driver has no valid driving license. Lordship. After accident, he has not. In our appeal, Lordship, paragraph 47, 4, Lordship, we have clearly stated that.
That plea was not in the WS.
Yes, WS is not there, Lordship. After passing the judgment, Lordship, that our concerned investigator, Lordship, due to his lapse on his part, Lordship, that he has not submitted the investigation report in time, Lordship. Accordingly, Lordship, the branch manager.
No, before that, let us come to IA number 3081. This IA has been filed by you.
No, Lordship, I has been filed
By me.
You.
Yes, Lordship.
For what?
For withdrawal
Of
of
the
our 50% of
But
the.
what can be withdrawn?
There is no
Unless there
order.
is some deposit,
Yes,
Yes,
Lordship.
Deposition order is necessary,
but you have prayed for withdrawal. There is-
Another prayer is also there to deposit this, I don't remember, my prayer
No,
kindly
no,
page
we cannot-
6.
But,
To deposit 50% of
let
the
this be
awarded
approached.
amount of rupees so and so before the registry of petitioner, and thereafter please to allow your petitioner to withdraw the said deposit amount, 2,10,000. That case, my lord. He was a
We
kind of
cannot make this
shopkeeper.
prayer, lordship. For depositing that
Already
amount.
deposited, my lord, that amount.
No, lord. There is no order, lordship.
Oh, yes. Possibly it was deposit.
There is no stay,
Stay, lordship, in IA lordship, I think. lordship.
which I,
He has annex lordship in IA lordship.
which I number,
IA 3081 23.
Sudeep.
IA
record-
number 2260.
record bila
lordship.
kya dibo? How will I reach there?
IA number lordship 226023.
I number
2260
2260.
23.
MSC appeal will be 306. They filed.
I number 2260. It is not there.
In MSc appeal number 306. And that IA is disposed of, lordship. On 27/9/23, lordship. There is a order.
And what stage the MSc case is been? This is of 2023.
Yes, lordship.
Accident occurred in the year 2013, my lord. Date of accident 22/6/2013.
13.
Tanu Mohan Rai, he was 25 years old.
Then you have to make prayer for modification of the order passed in I number 2260. Because I number 2260 stay was granted without any condition.
Raise any concern.
Without any condition.
Yes, my lord.
Now,
Yes.
if you want a condition to be imposed, that order has to be modified.
But lordship, at that time, lordship, the deposit of 50% is not there because we have challenged the entire judgment, lordship. If the appeal is lordship allowed, then lordship owner has been satisfied the award, lordship. As because driver, at that time, driver has no the driving license, lordship. After accident,
There
lordship,
is a probability that liability may shift to the owner.
owner, lordship. That's why, lordship.
Then what is to be done?
No, but nowadays, this recent matter development is that matter fact, on the ground of fact, license, etc. It was there, my lord, it is mentioned. Only some 7-6 days already there, my lord.
Not now.
Lapses. And it is mentioned in the judgment itself, my lord. Specifically mentioned in the judgment. Driver filed the WS, my lord. Base, my lord, that is 17.
No, you have made wrong submissions in your interlocutory applications. You have made that the stay was granted subject to payment of
50%.
deposit of 50%. That is,
Yes, my lord,
wrong facts are stated.
Dispose of Lordship that petition.
On that ground, this petition is liable to be rejected. You have
but
made wrong
prayer,
submission,
prayer I have mentioned, but that is their mistake.
but that is a false statement.
Statement, yes,
Yes,
Lordship.
my lord.
Heard Mr. H.R.
Put liberty to file, my lord. Because I'll, yes,
No
it is
liberty,
the-
Lordship.
typed
You are
out,
withdrawing this. You are
Yes, my
withdrawing.
lord, withdraw and file another application.
The Lordship. In
Because in the prayer, I have specifically mentioned, my lord, to deposit 50% every year and compensation before the registration and thereafter be pleased to allow your petitioner to withdraw the same.
Heard Mr.
Somehow it is-
H. Das, learned counsel for the respondent.
applicant.
What is this appeal 461?
This appeal, cross appeal has been filed by me, my lord,
Okay,
because there are multiplication has been counted from
okay,
by
okay.
claimant.
In item number 38, heard Mr. H. Das, learned counsel for the respondent number,
461 is filed by me, my lord. I am the appellant.
learned counsel for the applicant.
Yes, Lord, he is applicant, Lordship. In
Applicant.
the I
Also,
Lordship.
also heard Miss,
I am for respondent number 1, Lordship.
your
In
name.
I.
Miss M. Chaudhary,
I am D.D. Burman, Lordship.
your name is also not, yes,
Yes,
yes.
earlier,
Heard
Lordship.
Mr.
Dr.
D.D.
India.
Burman, learned counsel for the opposite parties. This is in I number 3081.
Yes.
Learned counsel for the applicant submits that due to inadvertence, some typographical errors have crept in the applications made by the applicant. Hence, he seeks he submits that the applicant may be allowed to withdraw the instant interlocutory application with liberty to file afresh. Considering the fact that the IA number 2260/2023 was heard and disposed of without issuing notice to these notices were not issued earlier.
In this I Lordship.
In earlier IA 2260, where stay was granted. Without issuing notices to the opposite party claimants, the prayer for withdrawal with liberty to file afresh is hereby
That
allowed.
was disposed of Lordship. That I was. 2260. Lordship.
This application I am allowing, withdrawal is allowing, I am allowing the withdrawal with liberty. They can file, but this is disposed of on, dismissed on withdrawal. In MAC appeal, MAC number 306. Heard Mr. H. Das, heard Miss
D.D. Burman. or
D.D.
appellant.
Burman, learned counsel for the appellant.
Yes.
Also heard Mr. H. Das, learned counsel for respondent number
1.
1. Who is you are appearing for any?
No.
Who is appearing for? Nobody appears for respondent number
2 and 3, Lordship.
2 and 3.
Service complete.
Service complete, Lordship.
Though Wakalatnama has been filed for them in this case. Stop. It also appears that the record of the concerned MSC case has also been received by the registry. Let this case be listed for, this case is listed for admission hearing after 4 weeks. And in MSC appeal number 461, that is item number
Appeal to be
39. 39.
That appeal is not admitted.
No.
Service is, I think, not completed, Lordship.
Service is not notice
Subsequent appeal, Lordship.
delay.
In 461, this is for enhancement.
Enhancement, madam.
You are appearing for
No,
this,
Lordship, in the, I am not appealing, I think. Someone
this,
could appeal. Could appeal also, Lordship.
No, আগতে condonation delay গেছি।
Delay someone. I think there is a delay.
there is delay.
Delay has been
That was
condoned.
not,
Delay has been condoned in which
Condoned.
I,
461.
in which I,
I am a lot. That is my lot, IA number 86823, 868.
heard
Order.
Mr. H. Das, learned counsel for the appellant.
27,923.
This appeal under section 270, 173/173 of the MV Act 1988 has been filed by the appellant/claimant praying for enhancement of the quantum of the award passed by award granted to the appellant by judgment and order dated 28/2/2017 in MSC case number 97/2014 passed by learned Motor Accident Claims Tribunal, Gwalpara. Issue notice to the respondents. You are not appearing for insurance company.
I have not entrusted, Lordship, in this state. Lordship.
Issue notice to the respondents. The appellant shall take steps for issuance of notice to the respondents by registered post with headache as well as by usual mode within 3 days from the date of this order, returnable on 2nd of September 2024. List accordingly.
Obliged.
Obliged.
Number 40, 31.
Yes.
May I please your lordship?
What, for what the interlocutory application?
These two are analogous matter, Lordship, arising out of same accident. Lordship. 41 and 42.
No,
40 and 41.
This IA 3694
Yes, Lordship.
Your lordship
is for what?
is for, this application is for seeking direction for release of the amount, 50% of the awarded amount which was deposited by the appellant insurance company.
On what ground appeal has been preferred?
Lordship, the ground is that, Lordship, our insurance company, appellant insurance company, is the insurer of the truck, lordship. And as per our evidence, we have given evidence before the tribunal that truck was in a stationary position, lordship. And the motorcycle which was driven by the deceased along with his friend knocked the backside of the truck, lordship. That is the factual position. And that is proved by one of our defense witness, lordship. And that was not considered, lordship. And accordingly, award was compensation was awarded against us, insurance company of that truck.
There was no contributor in it.
No, lordship, it should have been, lordship. That is our case, lordship.
And when the accident occurred, in night or daytime?
Yes, lordship. It happens on 28/12/2018. It's about 5:40 PM.
Evening.
And lordship, mainly lordship, the insurance company is not made party.
You have any objection
Yes, lordship, we have filed objection to that, lordship.
releasing of the amount?
Yes, we have filed, lordship.
What is the objection?
Objection, we have filed, lordship, this IA 369 of 2023, lordship. Because law court record has already been received, lordship. My humble prayer is that, lordship.
Can be heard and discussed.
Yes, it may detail, lordship may hear the matter in detail because law court record is there only for a few days, lordship. Next week or day after that, lordship, as per my learned counsel's convenience.
It is my application. My application is that the amount which was deposited in the year 2018 should, otherwise I am losing interest. Till today, I have lose 1,92,000 of interest on that amount. Registry will not pay me any interest. And this matter will take another 5 years.
Why?
For disposal.
Why?
2012 appeals are pending. 2010 appeal are pending.
No, that cannot
And
be.
my learned friend is misleading the court. That record are there.
Therefore, lower court
In
record is
many
required,
cases,
lordship.
lower court records are
Required, lordship.
here in High Court since 10 years. Whether the appeal was
Misleading,
disposed of.
lordship, he has just come now only. Only on 2 occasions he prayed. This is filed only in the year 2023.
Your-
Along with a petition for cross objection, lordship.
Your-
That too with delay. He is asked to file a petition for condemnation delay of cross objection. That was not filed,
May I
lordship.
please your lordship?
There is an order of this honorable court.
May I please your lordship?
Now misleading
Now,
word should not be
ha-
used like
What
that.
has happened to cross objection?
That has been admitted.
That is delayed, lordship.
Your lordship,
Cross
Honorable-
objection is for enhancement.
for enhance-
For enhancement, and it was delayed, lordship. It was beyond the limitation
your
period,
lordship, I may
lordship.
be allowed to submit on my release application. If your lordship is not satisfied,
That is,
then your lordship may reject it.
Yes, make your submission. Yes.
Your lordship, I will come to their objection. Their only objection is that there was negligence on the part of the driver of the motorcycle. Paragraph number 5, your lordship. Objection. Objection filed by the insurance company.
There is only one additional affidavit of required. Concernment property.
Paragraph number 5, their only
No.
contention.
The additional affidavit is as regards bringing of the age proof document of the applicant. No, nothing else.
yes,
No, that one is different one, your lordship.
that is, lordship, regarding this Nijora Tamang, lordship. Now she was minor at the time.
At the
No,
time,
in
And
In
he has, my learned friend has filed this.
No. In IA number 3694,
Yes, the
which
court,
was the prayer, which was filed for releasing the 50% of,
Yes.
you have filed an additional affidavit.
your lordship, at the time of filing of the MSC claim case, the claimant was minor.
So it is to
The court
that
court
she is now major.
now measure. The court
Now, where is
asks,
your objection? Your objection is not on record.
Your Lordship, we have filed on 7/6/24.
Record
7/6/24.
will not currently maintain column. Objection is not there on record.
in the IA 3694,
In IA 3694,
Yes, Lordship.
the objection should be in IA 3694.
Yes, Lordship.
yes, in 3694, neither the office note reflects about objection, nor it is there on record.
The Lordship may allow some time, Lordship, we'll verify the same, Lordship, because,
You go through the record.
yes, Lordship,
Now you
yes,
go
yes,
through the
yes,
record.
Lordship, that will be better. Lordship.
Find out.
Yes, yes, stabilize, Lordship.
Number 42.
Could be into some. None appears for the applicant on call. Let this matter be listed again in the next week on a date to be fixed by registry.
Again, 43.
May it please your lordship. Here, my lord, I am about to file an additional affidavit, my lord. The affidavit is ready, my lord, but the concerned parties are yet to sign it, lordship. Some time may be granted.
Heard Mr. M. Zaman, learned counsel for the applicant, who prays for, who submits that the additional affidavit is ready, however, it is yet to be signed by the concerned parties, and on that ground seeks some more time for filing the additional affidavit. The prayer is allowed. Let this matter be listed again on
2 weeks, my lord.
after 2 weeks.
Much obliged, lordship.
Again, 44.
Lordship, Lordship, as per the office notes, Lordship, service has been served upon the respondent is not complete.
Not complete.
Yes. The service may be awaited by the.
You are for?
I am appearing for respondent, Biren Singh and Bimala Devi. We already filed our Wakalatnama on 26 July 2024.
You are appearing, na? Okay. Heard, Mr. What is your name?
S. Kathak.
S.
Kathak.
Kathar, learned counsel for the petitioners. Also heard Miss
G. Bora.
G. Bora, learned counsel for respondent number 1 and 2. As the service of notice on the respondents is complete, let this matter be listed for admission hearing. When do you want? After
2 weeks.
After 2 weeks on a date to be fixed by registry.
Item 45.
Yeah, his lordship. Lordship, service notice was issued to the respondent by registered with AD. Lordship, but inadvertent mistake, my lord, and also miscommunication with the clerk, notice was not taken.
You have not taken steps.
No, my lord, kindly allow me one.
Any interim relief was granted?
Yes, my lord, interim is
Then
there.
we are vacating the interim relief, interim order.
My lord, I will take.
No,
step.
why have you not taken steps? You at the once and you are seeking interim relief.
My lord, actually, I am junior advocate, so my lord, I will also unable to understand this. My lord, I will take within 2 days, my lord.
No, within 24 hours, if you are getting interim relief, then you have to take interim relief is granted without hearing the other side. Then within 24 hours, you have to take steps.
My lord, it is also inadvertent mistake and also miscommunication with the clerk, my lord.
Heard Mr.
H. Rashid.
H.
A. Rashid.
A. Rashid, learned counsel for the petitioner, who submits that that the petitioner could not take steps for issuance of notice on the respondents as directed by this court. How many respondents are there?
Sole respondent, my lord.
On the sole respondent as directed by this court by its order dated 21/6/2024. The prayer is allowed. However, prayer is allowed. The petitioner is allowed to take steps by issuance of issuance of notice upon the sole respondent by registered post with AD, as well as by usual mode, positively by tomorrow. The notices are returnable on 2nd of September 2024. List accordingly.
Item 47.
Yeah, please. May it please the lordship. This appeal lordship has been filed in the ground that this is admittedly a case of murder.
Case of
Murder.
Okay.
The claimant's deposition, the claimant and CW1, CW2. What emerges from the deposition is that the husband of claimant was murdered by the claimant's paternal uncle's sons. All of them are habitual offenders, some of them are in jail, some of them are that kind of several murder cases there. And on that day, it's supposed to be an inter-family feud, lordship. What happened? This husband of the claimant was going with the maternal uncle's sons, children. And their vehicle was confronted, the other side confronted them when they were approaching the IOC oil depot. It's a clear, and the charge sheet is there, lordship, the GRKC is there, page 47. It makes a very clear, it's all are under 302, all of them have been booked under 300. Huh? Sorry. There is one, I mean, one, respond number 6. Yes, number 6.
Lord, service in respect of respondent number 6 is not completed, my lord, number one. Number-
That's why here say delay condon R1 to R6 appeared.
No, 1 to 5. I am for 1 to 5, my lord.
1 to 5.
I am for 1. Notice. Last
Yeah,
report,
R1 to R6 appeared, R6 appeared.
notice report is last report. And even, my lord, I have not got the copy of appeal memo and IA also, my lord.
You furnish
Okay, I'll come in.
in,
And I'll check the service lots in a minute on R6.
you are
I thought-
taking notice for respondent number 1 to 5.
I am for 1 to 5.
As against respondent number 6, you take fresh steps in
Yes.
main appeal as well as in the interlocutory application.
I'll do that.
Heard Mr. R. Goswami, learned counsel for the
This
application.
is just one prayer. I may be allotted justice sufficiency. That will make it expedited.
Okay.
On
Heard
R6.
Mr. R. Goswami, learned counsel for the applicant. This is in interlocutory application, huh? Interlocutory application 613/24. Learned counsel for the applicant. Also heard Mr. What is your name?
My lord, I am for FL Oscar.
F.L. Loskar. Learned counsel appearing for respondent number
1 to 5.
1 to 5. This application under order 41 rule 5 of the Code of Civil Procedure, 1908 has been filed by the applicant insurance company praying for stay of operation of the impugned judgment and order dated 3/2/2023 passed by learned Commissioner for Employees Compensation, Bongaigaon in EC case number 12/2021. Stop. The said judgment and order has been impugned by the applicant by filing the connected miscellaneous first appeal number 16/2024. Stop. Issue notice to the respondent number 6. The applicant shall take steps for issuance of notice on respondent number 6 by usual mode as well as by dusty mode. The notices are returnable on 3rd of September 2024. Same order in MFA. In MFA 16, heard Mr. R. Goswami, learned counsel for the appellant. Also heard Mr. F.A. Laskar, learned counsel for respondent number 1 to 5. It appears that the notices sent to respondent number 6 has returned back after due service.
Yes, it- So there's a note on 24, office note 25/7/24. It says R6 service complete.
Yes.
I missed it as my junior section. Office note 25/7/24. It's fine.
With a note of the registry to the effect that the notice issued to respondent number 6 has been duly served, and to that effect, a report of the process server the report of the process server is annexed with the said notice. I have perused the report of the process server of the office of the Civil Judge, Junior Division, Bongaigaon. And it appears that notices were duly served on the respondent number 6 on 3/6/2024 at 11:40 p.m. By obtaining the signatures of respondent number 6 on the copy of the said notice, in view of the report submitted by the process server, the notices issued to respondent number 6 is held to be duly served. Stop. It also appears from the case record that the case record of EC case number 12/2021 has been received from the Office of the Commissioner for Employees Compensation, Omega. As the notices are duly served on the respondent and the trial court record has already been received, this case is ready for hearing. Hence, let this case be listed for hearing after listed for hearing on a date to be fixed by registry. The learned counsel for the respondent number 1 to 5 has submitted that he has not received the memo of appeal along with the annexures. The counsel for the appellant is requested to furnish the same through the counsel for the respondent number 1 to 5. List this matter accordingly.
Along with IA, copy of IA. There is an.
In IA, there is no. In IA, you have to take fresh. Thus,
They are already there also. It can be matter can be hard now. Many days. Can be hard.
in IA, all of corrections. When to fix
Any treatment.
in IAM we dictate police already, and learned counsel for the respondent number 1 to 5 has submitted that he has not received the copy of interlocutory application. Hence, the counsel for appellant is applicant is requested to furnish the same to the counsel for respondent number 1 to 5. Stop. It appears from the office note which is available in the case record of office note dated 25/7/2024, which is available in the case record of MFA number 16/24, that the notice issued to respondent number 6 has been duly served. So, in view of the report of the process server annexed along with the available in the record, it is hereby held that notices issued to respondent number 6 is duly served. let this is be listed accordingly on which date?
After
Any
4
date,
weeks,
that is fine. Any date,
after 4 weeks.
after 4 weeks.
After 4 weeks on a date to be fixed by registry.
Obliged, Lordship. Obliged. Leave date.
Item 49.
Lordship, I have filed an appeal is already admitted. We have deposited the amount also. They have filed an application for withdrawing that amount. And we have also filed an objection that is not on record.
This I is for?
I for release of the amount deposited. And we have filed an objection that is not on the record.
That is not on record.
Not on.
That has to be on record.
I have received a copy,
You have received,
my lord.
but that is not before me.
Next week, Lordship will list this matter along with the objection.
No, it is there.
Affidavit is there, Lordship. Objection.
It is there.
Okay, no, okay, Lordship.
Oriental.
Lordship, Oriental. My submission to be Lordship, in this particular case, we have found this appeal on the ground that the driver of the offending vehicle, there is a collision between motorcycle and Maximo van. And we have produced defense evidence stating that there is no driving license of the driver and there is no valid permit at the time of the offending vehicle. We have been directed to pay 50% of the award by the tribunal. And this court has already admitted the appeal on this ground that the license was back. We have examined the DTO, person from the DTO office to prove that there is no permit at the time of accident. And the driver also did not have a license. That is why Lordship judgment has been stayed subject to deposit of 2,50,000. They want to withdraw the case. Lordship, earlier 147, there is a provision in the Motor Vehicle Act for pay and recovery. But now, after amendment of Lordship Motor Vehicle Act, there is no provision of pay and recovery. And Supreme Court has time and again said that Supreme Court giving the order pay and recovery under Article 142 of the Constitution of India, that is the Supreme Court power under 142. But this court and the Mehmet City Court did not have the power to pay and recovery because 142 power is only on the Supreme Court. That is my case.
Pay and recovery power is not there.
Pay and recovery earlier Motor Vehicle Act, there is a provision under section 147 of the Motor Vehicle Act. There is a statutory provision. If there is a policy of insurance, you have to pay the victim. Then you can recover from the owner of the vehicle. So my submission will be Lordship will finally dispose that matter. Any date next week or as per their convenience, finally dispose the matter.
Regarding final
And
hearing,
Lordship, there is a judgment of the Supreme Court. That is, Lordship, Supreme Court has categorically stated that if owner has given a bond before the tribunal, before the High Court, that he will deposit the amount before the court, then it will be released, subject to giving bond by the owner. Because payment is to be made by the owner. We have to reimburse the owner. But
Whether owner has appeared.
Owner, I have not checked out the record also.
Because otherwise, if we release the fund,
there is
in
no
the
such
event of allowing of the appeal, the fund, you have to refund back that fund, which is normally difficult for the claimant.
my lord, my lord. But my submission is that my learned friend has submitted on 2 points that there are no driving license and permit was not there. But regarding driving license, I would like to rely on judgment IFCO Tokyo Insurance Company Limited versus Geeta Devi and others. Right now, I am not the copy at my hand, but here the Honorable Supreme Court has held that mere absence, fake or invalid driving license or disqualification of the driver for driving, not valid defense by insurance.
That is earlier judgment, I think, Lordship. This is not the judgment after Supreme Court amendment of the Motor Vehicle Act.
And regarding the second submission of my learned friend, my lord, the permit, my lord, may I take your lordship to the judgment for a moment, my lord? It is clearly discussed, my lord. Paragraph 30 may kindly be seen. page
No.
13 of the appeal. My
Will you give an undertaking that in the event of
My lord, my
allowing,
lord, I am
allowing of
ready.
the appeal?
I'm ready to give undertaking.
No, you will readily file the undertaking, but it is difficult to comply with the undertaking later on. That is our experience.
If he get bond, let's say, claimant give a bond before the registry.
Indemnity bond.
Indemnity bond.
It will be recovered from the.
He can give an indemnity bond, we'll try lots of recover. Subject to giving an indemnity bond before the registry.
Heard Mr. S. Alim, learned counsel for the applicant. Also heard Mr. S. K. Goswami, learned counsel appearing for the opposite party insurance company. This application under section 151 of the Code of Civil Procedure has been filed by the applicants / claimant, namely how many claimants were there?
2 claimants.
Mazeda Khatun and Sazeda Khatun, praying for directing the registry to release the 50%.
50% of our liability you have deposited, plus 2 lakhs and all we have deposited.
The 50% of the
liability 50%.
awarded amount.
2
What
lakh
was
50,000.
the,
We have deposited 2,50,000.
what was the awarded amount?
Amount was 11 lakhs and all. Our liability is 50% of that.
50% of the liability of the opposite party for paying the awarded amount, which has already been deposited by the registry.
We have deposited only 2,50,000 as directed by this court.
Okay.
Lordship will find in this case the order of this honorable court. Page,
No, I took
page 10, Lordship.
praying for one of Kati. Heard Mr. So-and-so, this application is so-and-so, has been filed by Agoto Eketakimu, filed by the applicant's claimant for release of the amount of rupees 2,50,000
In compliance of the High Court's order dated 24.
deposited by the opposite party before the registry of this court in pursuant to the directions of this court by order dated 24/8/2018 passed in IA within bracket C number 3017/2018 as a condition for stop, no, 2018 stop. Said deposit was made by the opposite party as it was the condition precedent for suspension of the impugned judgment and award during the pendency of the connected appeal. Learned counsel for the applicant has submitted that though the Motor Accident Claims Tribunal number 2, Kamrup Metro, Guwahati, by the judgment and award dated 2/6/2018 was pleased to direct the payment of compensation of an amount of rupees 11,03,752 to the applicants. However, out of this amount, how much you have received?
Nothing. received.
Nothing. However, till now, they are unable to enjoy the fruits of the said order due to pendency of the connected MAC appeal, that is MAC appeal number 747/2018. Learned counsel for the appellant has submitted that this connected appeal has been pending since last 6 years, and hence since last 6 years. And there is unlikelihood that the appeal filed by the appellant would be successful. Hence, he has prayed for releasing the amount deposited by the insurance company in favor of the applicants. Stop. On the other hand, Learned counsel for the insurance company opposite party has submitted that the insurance company appellant has preferred the appeal on many grounds, inter alia, on grounds inter alia, that the driver of the offending vehicle did not have a valid license at the time of accident, and there is every likelihood that the appeal filed by the appellant would succeed, would be favorable in the appeal filed by the appellant. Favorable orders would be filed and liability is likely to be shifted to the owner of the vehicle involved in the accident. Hence, he has opposed the grant of, he has opposed the prayer for releasing the money which has been deposited by the insurance company to the applicants during the pendency of this. During the pendency of the connected appeal. Stop. I have heard learned counsel for both. I have considered the submissions made by learned counsel for both the sides, as well as peruse the materials available on record. It appears that though the operation of the impugned award and judgment was stayed in interlocutory stayed on 28/8/2018. However, even after lapse of 6 years, the appeal would not be heard and finally disposed of. In view of the aforesaid facts, if the apprehension raised by the counsel for the insurance company may be taken care of by directing the applicant to furnish an indemnity bond in case the deposited amount is directed to be released in their favor. Stop. In view of above, the registry moreover, it also appears that the order dated 24/8/2018 passed in IA within bracket C number 3017/2018 was passed without issuing notice to the above named applicants, and therefore they did not have any opportunity to oppose the prayer for execution of the stay. Prayer for stay of the execution of the impugned award and judgment. In view of above, the prayer for release of the deposited amount of rupees 2,50,000 in favor of the applicant claimant, namely Mazeda Khatun and Sazeda Khatun, is hereby allowed. The registry is directed to release the amount of rupees 2,50,000 deposited by the insurance company within bracket opposite party, subject to furnishing an indemnity bond by the applicants to the registry of this court to the tune of rupees 2,50,000. With above observation, this interlocutory application is disposed of.
I'm highly obliged.
Number 20.
What is this?
May I please, your lordship? Lordship, this is an application for release of the 50% of the awarded amount deposited by the appellant insurance company. In this case also, your lordship, my learned friend has filed objection.
What was the ground?
Ground of appeal is that they have denied the involvement of the vehicle.
Vehicle,
Lordship, our vehicle was not involved in the accident, Lordship. That is our plea.
oh,
Your lordship, some of the material facts have been suppressed by the insurance company. In this particular case, owner and driver of the insurance company appeared, they filed written statement. Categorically admitted the accident, involvement of the vehicle, only denies the rash and negligent driving. And the insurance company has not deduced any evidence. And the case has been charge sheeted. The driver has faced the trial. I have examined one eyewitness also. That eyewitness, what he have stated in the GR case, does not tally with the evidence filed before the evidence stated before the tribunal. That is the only ground by which they came to the conclusion that the vehicle was not involved.
no, what was the only ground?
We have examined one PW2 eyewitness. That eyewitness also appeared before the CGM court in the criminal trial. In that, he had said that he had not seen the accident. In MSC claim tribunal, he has stated that he has seen the accident. And in GR case, his statement is that he has not seen the accident. This is the only ground. But the case has been charge sheeted. The driver faced the trial. The owner driver filed written statement admitting the involvement of the vehicle. And what evidence has been reduced by the insurance company? If your lordship come to the memo of appeal, without any evidence, this kind of allegation, your lordship, in the memo of appeal,
No, what this I number 3870 is for? In which IAB?
Lordship 3870, Lordship, they had filed, Lordship.
I have filed I have filed that application for directing the appellant to deposit 50%, which is otherwise mandatory. In money, these are all money appeals. Money appeals, deposit is mandatory. It is my contention. And the
Mandatory
court-
under what provision?
Order 41, Rule 1, Sub Rule 3.
Okay.
Now, the court has directed them to deposit. So after deposit, I am before your lordship.
Before that stay was granted without any order
Yes.
of deposit.
That stay was vacated.
Vacated in which case?
In my IA, 3870.
Thereafter, they deposited the.
They have deposited, and accordingly we file an application for release of the same.
How much was the compensation?
Compensation is 20 lakhs, 97,000 odd. And they have deposited 10 lakhs 48,688. Your lordship, for a moment, peruse the memo of appeal, your lordship.
Yes. What is the probability of
Your lordship,
appeal being allowed? Assuming that appeal is allowed,
according to me, there is no probability of
but
allowance.
assuming that it is allowed,
Your lordship, page number 15 of the memo of appeal. One five.
yes.
Your lordship found it? Your lordship, claimant number 1 examined herself as PW1 and also examined 2 other witnesses, PW2 and 3, and produced number of documents in support of their contesting opposite parties have not examined any witness in support of their case. Without any evidence,
Okay, what is the basis of seeking that money during?
yes, your
Say,
lordship,
under order 41 rule 1
sub rule
clause
3.
3, They have
Sub-rule,
deposited.
no, this, yes.
They have deposited. So
Deposit.
there is an assurance that some security is there.
Yes, if my learned friend insists or if the court directs, I can file an indemnity bond. In any way, they can recover it by filing proper suit. And Your Honor, if
No,
your
no,
lordship,
why to go for suit?
if your lordship, contesting parties have not reduced a single evidence, just on assumption and presumption, without any pleading, without any evidence. This grounds has been taken in the appeal.
The insurance company has not led any evidence.
Any evidence, it is written in the judgment itself.
Yes, Mr. Sakya.
Lordship, in this case, my learned friend has insisted on the WS filed by the owner, Lordship. Owner has filed WS, but that was not proved by the owner. The contents of the WS is doubtful, Lordship. As because, Lordship, insurance company had asked for direction to the learned CGM to send the GR particulars. The GR record was very much in the LCR, Lordship, it is there. So as per Lordship GR, Lordship may be pleased to go through the LCR where it is deposed. The witness on the basis of which evidence the case was disposed, and my learned friend is insisting that his deposition is true as regard the fact of the accident is not at all correct, Lordship. The witness who have deposed here in this MSCT case deposed completely different the CGM code, Lordship. That Lordship may please be.
Yes, assuming that he is regarded as unreliable witness.
Yes, Lordship.
Then his evidence goes, suppose in both the cases.
Yes.
Then in MEC case, whether any other evidence is there.
Lordship,
Lordship.
let my learned friend submit that.
Lordship, in this regard, Lordship, owner of the vehicle also deposed in the GR case, Lordship. He also stated that my vehicle was not involved in the accident. I don't know. Lordship may please go through.
No, that was not his statement. His statement is, I was not aware. I was not aware of any such accident.
When Lordship owner is not aware that his vehicle was involved, how that we can assume that his vehicle was involved in this accident? Some other vehicle was involved, Lordship.
Your Lordship, the tribunal should rely upon the evidences which is laid before it. If some evidence has been laid in other court.
No, wait. He was cross-examined.
Yes, Lordship.
During his, when he gave his testimony before the tribunal.
Before tribunal, one Mr. Siddharth had come, who had deposed also in the GR case where he stated that he is not aware about the involvement of this vehicle.
No, not involvement. You are again making incorrect submission.
Lordship, maybe please to go through
Your
the
Lordship,
LCR, Lordship.
Your Lordship.
I am reading the.
Your Lordship, he has said, I have not seen the accident. Is it?
Owner or driver?
Correct? No. The PW2 which appear in the claim case.
What is the name?
Siddhant, I think so.
Lordship,
He deposed both before the MSCT tribunal as well as in the CGM court. For the time being, if your Lordship, if we forgo the evidence, let consider this as unreliable. That no, the tribunal are not reliable. Even though the charge sheet will stand.
And what
charge sheet will stand. Charge sheet is prima facie evidence of negligence of the other vehicle. I have other judgments also. I will rely upon.
But
this is first charge sheet.
But
So there is a probable. No, these questions I am asking.
Now, my learned, so far I understood, I may be wrong, subject to correction, Your Lordship, that the person who deposed before the tribunal, in my case, as a PW2 eyewitness, has also deposed before the CGM court, that is a GR case, the rash and negligent driving case. In that case, he has stated that he has not seen the accident. But in MSC claim case, he appeared and said that he had seen the accident and accident occurred due to ration. Perhaps this is correct.
Lordship, the person who had deposed in one court something else, in other court something else. So his evidence is not reliable, Lordship. And on the basis of
No,
that-
but but whether that was brought to the notice of tribunal.
Yes, yes, this is their lordship.
That
And
he
on-
deposed before in the
yes.
GR course in such a manner.
yes, 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 yes. lordship.
How it will be
This-
brought to the notice of the court? No evidence has been reduced by insurance company.
Because
The case record was called for, and
Yes,
that has
lordship.
been called for.
case record
But
is
to
there.
rely upon that case record, there has to be some evidence.
This is lordship, and ultimately, the driver who was alleged to be rash and negligent in this case, who was charged, he was acquitted, lordship, on the basis of the evidence. In the
Lordship,
in the GR case, lordship, our driver was acquitted. No case of rash and negligent driving and involvement was
No,
proved, lordship, in the
but
GR
the
case.
standards are different in both the. Let them file indemnity bond.
Your lordship, I have one judgment of Supreme Court, Anita Sharma's case.
What it says.
In this case, I am reading. Adverse inference drawn by the High Court is wholly misconceived and misdirected. Not only is the owner cum driver not the author, but instead he is one of the contesting respondent in the claim petition, who, along with insurance company, is an interested party with pecuniary stake in it. If the owner cum driver of the car was setting up a defense plea, that accident was result of not his but carelessness or rashness of driver of truck, which was coming from the opposite collided, then the onus is upon the owner cum driver of the car to step into the witness box and explain as to how the accident taken place. Fact that the owner cum driver choose not to depose in support of what he has pleaded in his written statement further suggests that he was himself as fault. Now, in this case, owner driver have filed written statement, but they have not adduced any evidence. They have not deposed before the tribunal. If it is the owner and the driver who are the best person to say whether their vehicle was involved or not. They are admitting they have only denied the rash and negligent driving. I have gone through the WA.
Heard Mr. D. Mondal, learned counsel for the applicant. Also heard Mr. A. J. Soikia, learned counsel for the insurance company opposite party. This application under section, where is the provision that you can take?
Actually, there is no provision. It can be filed even under 151 also. Actually, generally, the release order is passed along with the deposit order itself in earlier days. Nowadays,
No release order. There is no such provision because the deposit is for security, which is as per order 41, rule 1(3), which they have complied with.
no. So far, deposit in
But
other
that
cases.
security is to be released only after disposal of the appeal.
No.
No,
Many cases of Supreme Court,
no, it has.
entire amount was released, 50% released without bond, 50% with bond. I have judgment. In
No, what will happen?
Malwa Street versus, there are many other judgments, Shaw Wallis versus.
You
Nepal
should
Court.
have come up with those judgment today.
No, Malwa Street I have with me.
Show me. Opposite party. Relevant para?
Relevant para. Then last paragraph also, we therefore having regard to the facts and circumstances of the case, direct the respondent to deposit 35 lakhs within a period of 4 weeks. Respondent shall furnish adequate security for rest of decretal amount within the same period. Appellant shall be entitled to withdraw a sum of rupees 30 lakhs out of the said deposited amount without furnishing any security and rest amount on furnishing security. This case went to Supreme Court.
Text may be different from this
No,
one.
no,
lordship.
no.
Order 41, rule 1, sub rule 3, everything
You
has
are
been
showing me
explained.
what was done by that court. It is an
Stay on money decree.
No, but what was the logic for doing so? How it was the reason? Because reason will help you.
Ordinarily, execution of money degree is not stayed, inasmuch as satisfaction of the money degree does not amount to irreparable loss.
Yes,
That
that may be
irreparable,
one reason.
irreparable loss is there in stay by appellate court. Irreparable loss and injury, an event of the appeal being allowed, the remedy of restitution is always available. Remedy was
Yes.
available to them.
Give it to me. This application this interlocutory application has been filed by the applicants/claimant praying for release of the 50% of the awarded amount, which was deposited by the appellant insurance company before the registry of this court in pursuant to the order dated 9/6/2023 passed in IA within bracket C 3870/2022 arising out of MSC appeal number 157/2022. Learned counsel for the applicant has submitted that the impugned judgment and award, which has been challenged by the insurance company in the connected MSC, that is MSC appeal, that is MSC appeal number 157/2022. An amount of rupees how much?
It is 10,48,688.
10 lakh for no, amount of rupees 20 lakhs
No, 50%.
97,376.
Lordship, that was rounded up to 400.
Rounded off to 20,97,400 was awarded to the applicant's claimant. However, even after lapse of more than 8 years of the passing of the impugned award, the applicants/claimant have not received even a single penny of the awarded amount, for which they are facing undue hardship due to the death of the sole breadwinner of the family. Learned counsel for the applicant has also submitted that the insurance company led no evidence during the inquiry before the Motor Accident Claims Tribunal, and there is unlikelihood of the appeal filed by them being
Lordship,
decided
we
in
had
their
called
favor.
for the GR record, the Lordship, this is the Lordship. We are directed to call for the GR record, and accordingly, the tribunal have called.
On the other hand, Mr. A.J. Soikia, learned counsel for the respondent insurance company. On the other hand, learned counsel for the opposite party/insurance company has submitted that there is every likelihood that the appellant may get a favorable order in the appeal filed by them. And in that event, they would be absolved of their liability to pay the compensation to the opposite party claimant, to the applicant slash claimant. Learned counsel for the applicant, learned counsel for the insurance company has also submitted that the plea taken by the insurance company in this appeal, that the vehicle which was shown to be involved in the accident and which was insured by the insurance company was in fact not involved in the accident in question. Stop. He submits that same would be apparent from the testimony of PW2, who deposed before the GR case. GR case number?
Lordship,
So the
2283/15, CGM 67.
GR case number 2283/15, wherein he deposed as a witness and has stated that he had not seen the accident. Stop. To counter the submissions made by learned counsel for the insurance company, the counsel for the applicant claimants have stated that even if has stated that the insurance company has not produced, has not adduced any evidence in support of the claim made by them before this court in appeal. They have only prayed for requisitioning the case record of the concerned GR case. It is also submitted by learned counsel for the applicant that an award passed in motor accident claims case is akin to a money decree in favor of the claimant. And the same principle
In terms of section 169 subsection 4 of MB Act.
in terms of section 169
Subsection 4,
MB Act sound.
new amended MB Act.
What it says,
It is akin to money decree. What
It
your
says-
lordship have read, yes. 169 subsection 4. And it can be executable like a money decree. Now the tribunal are also empowered to execute this.
which amendment?
A new amended act, section 169 subsection 4.
There is no 4 in section 169.
No, I have read. You have to do.
Go. He also submits that ordinarily the execution of a money decree is not stayed in as much as the satisfaction of money decree does not amount to irreparable injury in the event of appeal being allowed. The remedy of restitution is always available to the successful party. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on the court. It is true that in this case, the compensation was awarded to the applicant slash claimant way back in the year 2016, and till date they are deprived of the fruits of the said award.
Lordship, 2016 case was filed. It was disposed in 2022, Lordship.
2022.
Yes.
2000
24/1/22, the judgment passed by the MHT, Lordship.
2022. Then
এইটো amended নহয় নেকি? Amended টো অলপ মোটা তো। এইটো নহয়। নহয় নহয়, এই amended হৈছে যে এইটো বোধহয় পুৰণাটোৱে।
কিন্তু
পঢ়িছো নিজে চাইছো কি খৰচ কৰে।
this court is of considered opinion that under the facts and circumstances of this case, if the applicant slash claimant are allowed to take the 50% of the deposited money subject to furnishing of an indemnity bond, the no injury would be caused to the appellant slash insurance company in the event of appeal being decided in their favor.
Rules নহয়, rules নহয়। MPF নতুন, এইটো পুৰণাটোৱে।
Stop. In view of above, the appeal, this interlocutory application is allowed, and the registry is directed to release the 50% of the awarded amount deposited by the insurance company before it, subject to furnishing of an indemnity bond by the applicant slash claimants to the tune of 50%, to the tune of like amount. Stop. In the event of appeal being allowed in favor of the insurance company slash opposite party, insurance company slash appellant, the applicant claimants shall refund the said amount to the registry of this court. Where in the event
In indemnity bond, generally we address the same to the Registrar General.
to the registry of this court.
Your Lordship, it is there, subsection 4.
Of?
This is old act.
Okay.
This is not a new one.
Read that.
It is there. For the purpose of enforcement of its award, the claims tribunal shall have all the powers of a civil court in execution of a decree under the Code of Civil Procedure, as if the award were a decree for payment of money passed by such court in a civil
With above observations, This interlocutory application is hereby disposed of.
Thank you.
And in main appeal,
Main appeal LCR is there.
Service is completed, LCR has come, but Lordship, respondent number 5 is not served till now. He could not be served, Lordship. His wife also refused to accept notice.
in main appeal heard Mr. A.J. Saikya, learned counsel for the appellant. Also heard Mr. D. Mondal appearing for respondent number
1, 2, and 3.
1, 2, and 3. Now what will you do as respondent number 5?
Lordship, I will take one instruction, Lordship. Other than paper publication, there is no other way, Lordship.
Now what you propose to do? Paper publication or you will seek instructions?
Paper publication, I will first seek instruction from the client.
Learned counsel for the appellant prays for taking some instructions from the appellant insurance company in this regards and prays for some time for the same. The prayer is allowed. Let this matter be listed after 4 weeks.
Oblige, your lord.
बेटा, थोड़ा correction है.
Yeah, I know. We'll confirm.
We have seen, Lordship, objection is not in the record.
Objection is not on record. Let it be on.
Let it be on record. Your lord.
Yes.
Heard Mr. D. Mondal, learned counsel for the applicant. Also heard Miss
And George.
M. Chaudhary, learned counsel for the opposite party insurance company, as well as Mr.
Next one.
Okay.
41.
Number 1, 2, and 3.
Learned counsel for the insurance company submits that she has filed an objection to the prayer made by applicant claimant in this case. However, said objection is not on record and therefore she requests that the registry may be directed to place the objection on record. Stop. The prayer is allowed. The registry is directed to list this matter again after 2 weeks.
Yes, Lordship.
After 2 weeks, by placing the objection filed by insurance company on record. In MSC appeal number 55,
55 of 18.
It is ready
This
regarding
is
service.
admissible hearing.
It is ready regarding service. your
Lordship, it was already fixed for hearing as per order dated 5/4/24.
okay. Then
Your lordship, this hearing may be taken up after disposal of the I-8.
why? It can be, it is fixed for hearing.
Already
If
fixed.
the hearing start or if the hearing ended, then my IA will become infructuous.
But it will,
IA will become infructuous. I may get entire money, but even my IA will become infructuous.
but that will make no difference.
So that is the reason, your lordship, that IA may be heard first. Then
No, I is not of that nature that it has to be heard first.
Therefore, Lordship, it is fixed for hearing. Lordship.
otherwise, your lordship, then it will become infructuous.
Let it become.
And I am
infructuous.
losing interest on regular basis. Though I have said,
No, when you make such submissions, it appears that you are anticipating that hearing would take much more time. But we will,
to be very fair and honest, generally
but it is ready for hearing.
ready, but
Already fixed for hearing, 5/4/24. Lordship. There is the order of this.
there are cases which is fixed for 20 to
fixed.
30 times for hearing, but the hearing does not took place.
Then let us fix this for hearing this time.
Lordship.
Yes, your
Let us see.
but in this case,
As
there is
this-
one problem, your lordship. I have filed one cross objection also. That has to be heard along with the appeal.
Lordship, I have not yet received cross objection, Lordship. In the last occasion, I make objection on
I'm-
cross objection And he is asked to furnish a copy of me
Lordship,
by
I'm
verbally, not it is recorded.
extremely sorry for that.
I have not furnished.
Your Lordship, I'm
Cross
extremely-
objection is barred by limitation, Lordship.
So in that case,
Cross objection is barred by limitation.
Lordship.
There is no condemnation or delay
No,
application. Then it will,
not be tagged together.
the
It will
cross
not be heard.
objection has been admitted.
no, there is no order in the cross.
No, cross objection has been admitted. Cross objection has been admitted.
Main thing is that I have not been served a copy. Without giving me a copy, it was admitted, Lordship. It was.
For admitting cross
explained.
objection or appeal, there is no requirement to supply a copy.
Then how can I make objection, or if any objection is there?
Cross objection is admitted, Your Lordship, so far.
Now, today, this is item number 50.
No, this one is 40,
only 40.
40.
In 40, I am appearing. In 40, I have filed cross objection.
In IA 3694, we have passed orders. 3694. We got order to 3694. In MSC 55 of 18.
Now my cross objection is number
the
is 3 of
MSC
24.
55 of 18. No, let us pass order one by one. MSC 55 of 18. MSC 55 of 18. This is already fixed for hearing. IA 920 / 920 of 18. For what?
Lordship, 920. This is, Lordship, they have, 920 is the stay, Lordship. Stay. We have filed this, Lordship. IA for stay, Lordship.
It is still pending.
No, it is disposed of subject to, we are directed to deposit 50%, Lordship.
You have deposited.
And we have already deposited. Therefore, they have filed this petition for
Releasing of the same.
releasing.
No, then 920 has to be disposed of.
Yes, Lordship.
Why it is listed today? Because no order in IA 920.
Disposed of, Lordship. This one is-
Heard learned counsel for both the sides. It appears that in this case, the impugned judgment and order dated 29/5/17 passed by London Motor Accident Claims Tribunal number 1, Guwahati, in MSC case number 3165 was stayed subject to deposit of 50% of the awarded amount by the insurance company to the registry of this court. It is submitted by learned counsel for the insurance company that in pursuant to the directions of this court, the insurance company has already deposited 50% of the awarded amount. In view of the above, this interlocutory application stands disposed of. This 920 is disposed of. Then cross objection 3 of 24. What will happen in cross objection?
Lordship, I have not yet received a copy, Lordship.
Okay. Heard Mr. D. Mondal, learned counsel for the
Cross objector claimant.
learned counsel for the cross objector / claimant. Also heard Ms. M. Chaudhary, learned counsel for the opposite party insurance company, who submits that she has not yet received the copy of the cross objection application filed by the claimant side. The applicant is directed to furnish the copy of the same within 2 days from the date of this order. List this matter thereafter. List this matter again along with MAC appeal number 55/2018 after 4 weeks.
Most obliged.
What is MAC 115?
That is item number 41.
41.
Item number
MAC
41.
115.
I'm appearing on behalf of appellant lordship. 41 as per
No, why it
office.
was tagged with the above cases?
Because arising out of same accident lordship. In the
Counsels are
other
different.
case, both are moving in the scooter motorcycle lordship. He is the pillion rider, he was the rider lordship.
Here, the service of notice on
Yes.
6 and 7 is awaited.
Yes, lordship, that since these are owner and driver, they did not contest the case in the tribunal lordship. Maybe struck off,
It will not affect your case.
no lordship.
Heard Miss M. Chaudhary.
They are not present, appeared in the law court.
Heard Miss M. Chaudhary, learned counsel for the appellant. Also heard Mr.
S. Rana,
S. Rana, learned counsel appearing for respondent number
1, 2, and 3.
1, 2, and 3. Stop. Learned counsel for the appellant has submitted that the notice of the service of notice on respondent number 6 and 7 is still awaited. However, she submits that as both the respondent had also not contested the claim of the claimant. What is your defense? What is your plea?
Case proceeded ex parte lordship against him.
No, in this appeal, what plea you?
Lordship, our plea was that our vehicle, the offending vehicle is the motorcycle who dashed against a truck which was in the parked in the roadside lordship. That is Sir
So
says.
if your appeal is allowed, to whom the liability will shift? Suppose your appeal is allowed,
In that case, yes, lordship.
the liability will shift to owner. Then notice is required.
It is awaited.
You have to either take fresh steps or await further.
We'll take first steps, lordship.
Learned counsel for the appellant submits that she may be allowed to take fresh steps for service of notice on respondent number 6 and 7. The prayer is allowed. The appellant shall take fresh steps for issuance of notice on respondent number 6 and 7 by registered post with AD as well as through usual mode within a week from the date of this order, returnable after 4 weeks. This is MAC 115. List accordingly.
Lordship, my learned friend is appearing for 1 to 5.
No,
1, 2, 3.
1, 2, 3.
Oh, Lord, I'm the same. And lordship, maybe come with the 41. Both the matter may come together.
Okay, let this matter be listed again after 1 week, along with MAC appeal number 55/2018.
Lordship, must oblige. Make me go.
Lordship, during the pendency of the appeal, Lordship, the appellant expired, Lordship. We have filed a substitution petition along with setting aside of abatement, Lordship. There is a delay of setting aside of abatement, Lordship. Okay. Respondent number one has appeared, Lordship.
You are for the insurance company.
Yes, Your Lordship.
You are opposing.
Yes, Your Lordship. We have not been served a copy of the setting aside of abatement petition, Your Lordship.
In 1689.
One,
in-
1688.
No, first we'll take up 168.
9. There is a delay.
Condemnation.
1689, condoning the delay. The appeal is not yet admitted. No, delay has not yet been condoned.
Delay has not been condemned.
Uh,
Earlier,
Miss-
appeal has been admitted, Lordship. It was fixed for hearing.
Which
And
one?
then in the meantime, this main appeal, Lordship. Main appeal.
Main appeal.
Then
Delay was condoned.
no, Lordship. Earlier the appeal was filed and the matter was admitted, Lordship. After that, Lordship, during that pendency.
Earlier the appeal was within limitation.
No, yes, Lordship. Appeal was within limitation that was admitted, Lordship. After that, after admission of the appeal, Lordship, the appellate expired.
Okay.
Then
For
the-
setting aside,
No, Your Lordship, earlier also there was a condemnation petition. It was,
That time, but that was
Yeah.
condoned.
but there was a condemnation petition for
Okay.
59 days. It was condoned.
That was condoned.
1689.
Appeal was-
Huh,
Heard
was-
Ms. P. Burwal, managed counsel for the applicant. Also heard Ms.
A. Biani,
A.
Biani, Biani.
A. Biani, learned counsel appearing for
Respondent number one.
respondent number one. This application under section 5 of the Limitation Act has been filed for condoning delay of 583 days in filing the application for setting aside abatement in MAC case number, MAC appeal number 393/2018 due to the death of who had filed that appeal?
Lordship, the legal error, Lordship,
Death of
the appellate.
who is Gurdeep Singh?
Gurdeep Singh is the appellant who is now expired.
He preferred the appeal.
Lordship. It was an injury case, Lordship.
Death of the appellant, Gurdeep Singh. Stop. Learned counsel for the insurance company has submitted that she has not yet been furnished with the copy of the interlocutory application. The counsel for the applicant undertakes to furnish the same within 2 days from the date of this order. Let this case be listed accordingly after 2 weeks on a date to be fixed by registry. And then MSC appeal 393.
Copy.
P93 is abated.
Lordship. Not abated. This one is a delay, Lordship. Then there is a substitution, setting aside. And regarding Lordship, respondent number 2, Lordship.
Why this 1688 has been filed?
Lordship, 1688 is setting aside of amendment.
This
is
will be
delay.
taken up only after
Delay is condemned.
delays condoned.
Then comes the substitution.
Okay.
And regarding respondent number 2, Lordship, 2 is the owner, Lordship. It's not a necessary party, Lordship, may strike off.
In 1689.
1689 lordship, because it's regarding quantum.
Learned in 1689 continue. Learned counsel for the applicant has submitted that as the presence of respondent number 2 may not be necessary for deciding the instant application, his name may be struck off from this interlocutory application. The prayer is allowed. The registry to strike out the name of respondent number 2, Shri S. Sardal Singh, from the instant interlocutory application. List this after 2 weeks. None appears for the parties on call. List this matter after 2 weeks.
Lordship, in this case, we were directed to take fresh steps, but we could not take. Kindly allow us some time.
Louder.
Lordship, in this case, we were directed to take fresh steps, but we could not take the steps. Kindly allow us some time.
You need some time, na?
Hmm.
Okay, heard Miss
A. Khitawat.
H.
A. Khitawat.
A. Khetawat, learned counsel for the
On behalf of me, P.
petition.
Deka.
On behalf of
P. Deka.
learned counsel submitting on behalf of Mr. P. Deka, learned counsel for the petitioner, who prays for some more time to take fresh steps in pursuant to the directions of this court given on 19/6/2024. The prayer is allowed. The petitioner shall take fresh steps within 7 days from the date of this order in pursuant to the direction dated 19/6/2024. The notice shall be returnable on 5th of September 2024. The interim order passed earlier shall continue. List accordingly on 5th of September.
Yeah.
Yes.
Lordly, I am appearing for the apparent in this case, and wide office memo order dated 3/7/24. Steps were issued upon the respondent number 1 to 5.
But report has not yet.
Yes, report has been awaited. Your Lordship, in the High Court website, there is an order of wakalatnama filing by the respondents.
All the respondents.
I have not gone, not the wakalatnama, as the wakalatnama has not been tagged.
Will await service report.
Yes, sir.
Heard Mr. A.K. Roy.
I'm B. Yadav appearing on behalf
B.
of B. Yadav.
B. Yadav appearing on behalf of Mr. A.K. Roy, learned counsel for the applicant. It appears that the notices issued to the respondent have not returned. Stop, await further. List this matter again after.
Your Lordship, respondent number 5 has refused to accept the registered card with ID.
Where is the report?
It's in the IA, Your Lordship.
But there is no such report.
Input is not there, your lordship, there is the acknowledge, ID card. That is separately tagged with the recording.
Learned counsel for the petitioner has submitted that the AD card available, AD card received back from respondent number 5 available on record shows that the respondent number 5 has refused to accept the notice. However, on perusal of the office note dated 26/7/2024, no reflection of the said fact has been made there in the office note. Therefore, the registry is directed to verify from records regarding the receipt of the AD card from respondent number 5, and thereafter put a proper office note before this court on the next date fixed. List this matter
Your
again.
lordship, there is an extra interim order.
List this matter again after 2 weeks. The interim order shall continue till next day.
Deeply applied.
May please your lordship, as per last direction lordship, I have taken dusty service upon all the respondents lordship. I have filed one affidavit dated before your lordship.
Notice served.
There are 5 respondents lordship. Dusty service was copy was served upon them lordship by dusty service lordship.
Against respondent number 2,
1 to 5 all lordship.
but there are only 4 signatures.
No lordship, 5 signature lordship. Lordship, left side lordship. Page 173, left side.
Heard Ms. P. Bhattacharya, learned counsel for the petitioner, who has submitted that the petitioner has served the notices on all the respondents through dusty mode in pursuant to the directions of this court. She also submits that the petitioner has also filed an affidavit of compliance showing the service of notice on all the respondent through dusty mode. I have perused the affidavit filed by the petitioner, which is accompanied by a copy of notice wherein the signatures of all the respondents are appended. Stop. In view of the above, the notices issued to the respondents are held to be duly served. Let this case be listed again for admission hearing.
Admission only possible on first lordship, because this is an injunction matter lordship. My room was locked by the respondent number 1 lordship, shop room lordship. If possible on first or second lordship.
Second Friday, how? First,
Okay.
let this matter be listed again on first 1/8/2024
For admission.
for admission hearing.
Yes, lordship. This matter lordship can you take up on Friday lordship. I have some urgency. My learned friend is also there lordship.
Sitting for the whole day, my lord. But already time is also.
So, lordship on Friday lordship. Second.
On request of learned counsel for both the side. No, heard Ms. P. Bhattacharya, learned counsel for the applicant. Also heard Mr.
B. Bora,
B.
for the
Bora,
respondent number 1. my lord.
learned counsel for respondent number 1. Due to paucity of time, this matter could not be taken up today. on request of learned counsel for both the sides, let this matter be listed again on
second of
second of August.
litigation. Alright, মই তলত গৈছো তো আমাৰ লগতে যাব লাগিব। ৰাতিপুৱা এক
কিয় কৰিছে নেকি?
আগৰ পৰা কৰি আছে তো ফাইলকেইটা ভৰাই তলতে last